honorable members who are present in this meeting. Unfortunately, it's our first meeting for the year. I think the other two meetings could not take place. But let me also formally thank honorable members for messages while I was sick for the second time with this COVID. Thank you very much for the prayers. It's good to be back. Thank you so much. I would also like to acknowledge and welcome the stakeholders and also thank them for responding to the advert that we issued for the two bills, the Employment Equity Amendment Bill, as well as the COIDA Amendment Bill. Thank you so much for responding. We have quite a number of stakeholders who will be presenting. Some will only present the employment equity and not present the COIDA. Some will present both. So we'll give the opportunity. So, honorable members, I will suggest, if you agree, that we allow the presenters, especially those who are presenting both bills, to present. We take notes, and then we can after ask questions. But we'll have one a presenter. For example, BUSA would present employment equity and COIDA, and then we allow then honorable members to ask questions. And after that, we take another stakeholder. I think it will be BUSA, if I'm not mistaken. And then if they have two presentation, employment equity and COIDA, they also do the same. And then we ask them question. If members agree with that approach, that would then will be the approach we'll be taking. Are there any apologies?
Yes,
Recording in progress.
I received one apology from Honorable Matabula.
Honorable Matabula, okay. I don't see other members. If perhaps
so if I can just go through the members, the members present we have today is yourself, Honorable Mamarafane, Honorable Mashodi, Honorable Bashov, and Honorable Tratusek.
Okay.
I too am present.
Honorable Dang was also present. Welcome. Let me also welcome the Department of Employment and Labor. I see the commissioner is present. I don't know if there are other officials from the Department of Labor. Also like to welcome the parliamentary staff, also including the legal unit of Parliament. I'm not sure if the office of the Chief State Law Advisor is here. I received a list earlier from Committee Secretary indicating, Assis Soraya is here, and Samantha Williams. You are all welcome to this meeting. I think I see also Ms. Isaac this year. Yeah, everybody then is welcome. If we agree, then can we then start with BUSA? BUSA, you are welcome. I don't know if you have given them the...
Yes, Chief, they have requested, and I have. Yes,
okay.
Yes, I have, and the assigned official from BUSA who will be projecting, I have given her the co-hosting rights.
Okay. So, okay. Who's presenting? Sino or Sino?
It will be the person who will be giving the presentation is Kaiser Moyane, but Sino is the person that you have been liaising with, who will open and drive the presentation from her side. So thanks, Sino, before I come in.
Okay.
Thank you so much.
Welcome.
Thank you. Just to apologize for the number of
differing versions that we have shared with the committee. Good afternoon. This is the final version, and we have updated it and sent it out, and we must apologize once again profusely. Kaiser, over to you.
Thank you, Sina. Thank you, Chair, and members, honorable members, I should say. I'm tempted to say, as I was saying last time, because it wasn't that long ago that I was talking on exactly the same topic, but to a different house, right? So we do welcome the opportunity to also come and share our views and concerns with this house on the Employment Equity Bill, and then of course the COIDA bill is going to be part of it, and so I will deal with both of them obviously one after the other. Okay, so I will take that the presentation has been read, and given the limited time we have, I wouldn't want to just read everything. So Sina, if you can just maybe move to slide 4.
Can you have it as a slideshow, Sino, please? Thank you.
All right, so essentially our starting point, Chair, is so that we are not our views are not misconstrued, is that whatever we are going to say, it's not to be taken as a denial that the pace of transformation in the country has been slow, and in some cases perhaps extremely slow. So BUSA accepts that. In fact, we do accept also that it's quite important that everything be done to ensure that workplaces are transformed as much as possible through the employment of suitably qualified people from designated groups. So that's our starting point. But of course, accepting that that's the case doesn't mean that we believe that the bill is necessarily addressing or presenting us with the best solutions to achieve that goal in all cases. We have in the previous presentation to the National Assembly made a point which was thankfully accepted by the Department of Employment and Labor in respect of consultation in terms of the proposed Section 15 capital A, and so for that we are grateful. Just go to the next slide, Sino. And so we will be addressing the next one. We'll be addressing the House essentially on 2 lingering concerns. And both of them deal with assessing compliance. So the first one, Chair, is the proposed amendment to Section 42, sub 1, paragraph small a, capital A, dealing with assessment of compliance. And in our view, this particular section should read whether or not the employer has taken reasonable steps to achieve the applicable sectoral target. And we have 2 main reasons for that. One is that if we capture it like that, then it aligns nicely with the rest of that section, because it all deals with the reasonable steps that an employer takes, a designated employer takes with regard or reference to compliance criteria. It is not, so it wouldn't be out of place. So, and that's how, to write legislation beautifully and consistently, we would prefer that it be captured as. And the second reason, Chair, is that if you don't write it this way, but you stick with the proposed version in the bill, then it amounts to quotas, because it says an employer must comply with this stated target, right? Whatever that number is. Now, a target is something that, obviously is something you aspire to achieve, and how you, the assessment of what you are doing, or the genuineness of your steps, is what's important. That the efforts you are making to get to that target, right? It's not whether or not you've achieved the target. So if the target is 100 and you've gotten to 99.9 and you haven't achieved the 100, regardless of all the efforts you've put in, you have not complied, and that we just think is inconsistent. So it makes the target, as stated, a quota, which would be in conflict with Section 15, sub 3, of the Employment Equity Act, which specifically says that quotas are not permitted. So we submit that in this particular case, the assessment should be on the reasonableness of the steps being taken by the employer, rather than on the achievement of the stated target itself. Go to the next one, Sino. So the second point of concern for us, Chair, and members, is in respect of Section 53. Now, this is an old section, we know. It's been there for the longest of time, and we have no issue with the section itself. But what we're taking issue with is the insertions now that are being proposed to give effect to compliance. Right? We think that those insertions, or proposed insertions, are actually not appropriate. So the first one, Chair, is that we think that it will actually fall foul of the Constitution, particularly Section 217, which deals with procurement. And I don't have to tell you, because that is your legislation, your law. You know that what it enjoins government agencies, bodies, departments to do when it comes to procurement. It doesn't mean that it's impossible to have a policy that seeks to, through procurement, seeks to promote interests of the previously disadvantaged. No, that's in fact specifically allowed. But what it does then say is that such a policy needs to meet, obviously, the framework of that entire section. So you can't have, and it must be then by a national legislation. Right? You can't have a decision of an official or even a minister via regulations or whatever, right? Not an act of parliament seeking to subvert that principle of the Constitution or that provision of the Constitution. So we think that would be problematic. So the setting of targets by the minister based on unspecified factors or for a variety of sectors, subsectors, regions, etc., in our view, Chair, would be problematic, would not satisfy Section 217, particularly sub 3. And so we submit that if the proposed Section 15 capital A is passed, even if it is part of national legislation, it still would not be setting a framework within which the policy would be implemented. And all it will do is empower the minister to set targets without reference to any prescribed framework. And as such, in our view, it will be unconstitutional, Chair, for being in conflict with Section 217. Thanks. Let's go to the next one. So, and those are the provisions that I said I don't need to tell you about what needs to happen. That procurement needs to be fair, equitable, transparent, cost-effective, and all that, in the interest of the state, obviously, and the public. So let us go to the next one. I've made the point about it being unconstitutional. Once again, we say that if it is passed, it will amount to an absolute bar, quotas, contrary to section 15.3. The other challenge with the proposed assessment of compliance and the issuing of the certificates is that it now brings in a criterion that an employer should not have any adverse findings about unfair discrimination against it in the last 12 months in the CCMA or in the labor courts. Okay. Now, Chair, we understand the intention. It's good. No employer should, in fact, be discriminating against its employees in any way if it's unfair. We do not take issue with that sentiment. What we do take issue with is that this provision seeks to subvert the powers of the CCMA and the Labor Court to determine its own processes and assessing what's appropriate for a sanction to deal with whatever mischief would be the subject of whatever case came before them. In other words, in the LRA, Chair, there is remedy built in there already for dealing with an employer that breaches the law, that law. So if there's a dispute, it goes through the CCMA or the Labor Court. And the employer, if the findings against the employer, will have to face some sort of a sanction. It may be payment of money, or it may be restoring whatever the rights of the employee are. But in that context of dealing with a dispute, Chair, we think it is unfair to then say, despite whatever might have happened in the CCMA or the Labor Court, we will still punish you because there was a finding against you in the last 12 months. You will not be able to do business with the state. That's double punishment, and it's irrational and it's unjustified. And then the same irrationality, we think, visits the criterion about the employer not having a finding of not paying minimum wages in terms of the National Minimum Wage Act in the last 12 months. You know, we again say that there are appropriate remedies in that legislation and in the Labor Relations Act for dealing with bad behavior, if you like, in there. And if and the reason I say, Chair, you know, for those who might still be unconvinced, is that those pieces of legislation also have their own processes for addressing whatever concerns a party, even if it's an employer, may have about those findings. So if there is a finding at the CCMA, for example, that the employer was wrong, the law allows the employer to follow legal processes to challenge that. But how is the minister now assessing compliance, or an official in the Department of Labor assessing compliance, going to determine, because all they will look at is that there is a finding against you, which will be factual, but that you are taking steps as an employer to appeal or to do away with that, to correct that finding, may be irrelevant to that official. We think, again, that is actually not right. It's unjust, it's irrational, and it should not be allowed to stand, Chair. So these criterion, we believe, should be done away with. Otherwise, they will simply lead to unnecessary disputes and challenges. Let's go to the next slide, Sino. So the final challenge we have with the proposals is that if they, which maybe it was not intended, but if employers in the sectors that are targeted are now expected to comply with these hard targets that the minister has determined for them. Then the question to ask is why do you bother consulting with your workers or the trade unions about the targets? Because in fact, that is part of what a designated employer is expected to do, right? To consult with his workers and trade unions about things like this. But if there's already a predetermined target by the minister, so why would an employer still want to do that? To go and consult about what? To come to the same predetermined target? So we think that this provision, Chair, if it is indeed to pass in the same proposed format, may be problematic in that it will then undermine the principle of social dialogue, which is so enshrined in our law that employers talk to their workers about things that affect the workplace relationships. And so we're flagging this again, Chair, as one of those areas that we were having a concern with. So those three that are lingering about the bill. It's the constitutionality of it. It's the conflating of remedies and imposing unnecessary punishment on employers, which will have dire consequences for employment. And then, of course, is this which is likely to result in disharmony in the workplace, Chair. If employers now decide that they do not need to consult with the workers, or they will simply go through the motions, which in and of itself is an insult to consultations. Chair, so those are the areas that we wanted to highlight in terms of the employment equity bill, and we do appreciate your time and your attention on this one. Thanks. I don't know whether I should then deal with the next bill before questions.
Yes, that was what I was suggesting earlier, okay. That you continue with the COIDA, and then members will then ask questions for clarity on both bills.
Thank you, Chair. Okay, this one maybe we'll go quickly as well. These are mostly technical concerns or suggestions that we have in respect of the COIDA amendment bill. So here on this slide is in respect of definitions, Chair. We think that as it's proposed, as it stands right now, to say particularly, and I won't read the whole thing, but that word disease there is too broad because it could refer to any kind of disease. Meanwhile, what we're looking for and what we're dealing with in the legislation is occupational disease, which is defined, in fact, in legislation. So we just think that that word should be should be occupational. In other words, should be inserted before disease. Let's go to the next one. Another concern is, and this is something that was addressed at NEDLEC, Chair, is that the act, or the proposal rather, seeks to transfer some of the powers that were currently being done, between the Director General and the Commissioner to, from one to the other. Now, whilst there may be nothing wrong with that, if it leads to efficiency, which is fine and we would welcome. What is particularly wrong would be where there's confusion in the process. So as we say in there, that during the NEDLEC process, we requested that government should carefully review the Act together with the amendment bill to ensure that sections relevant to the functions of the DG and the Commissioner are updated accurately to ensure that there are no contradictions or anomalies. And one of the inaccuracies that we've picked up is that Section 4 of the Act has not been updated to remove the functions of the DG, where these functions have been moved to the Commissioner. Right? And so it may, like I said, may be technical, so they just need to go do that. Thanks. Next slide. Chair, with regard to section 69, BUSA does not support the proposed amendment to section 69 so far as that amendment, the amendment bill suggests that the period for public comment should be reduced from 60 to 30 days. And it was in fact agreed at NEDLEC that the 60-day period will be retained, and there is no explanation why in the bill before you that the 30-day period has crept in. So we would like to revert to the 60-day period which was agreed at NEDLEC. Next one. So the one area, the big area, in fact, that is of concern to us is in regard to fines and penalties. During the NEDLEC process, Chair, the most significant area of disagreement was that around fines and penalties, right? Our view is that fines and penalties should be should meet certain principles, if you like, which we outline there. So a fine or a penalty, as for starters, must be an effective deterrent. We agree with that. A fine, penalty is the second one, must be proportional to the offense. The third one is that it's our preference that any prescribed fine or penalty should be a defined amount and not a percentage of an unknown amount. And fourth one is that a fine or penalty should have a maximum of up to, or a fine not more than. So that's the preferred wording, because it actually then allows for whichever official is seeking to impose the fine, it allows for discretion. And this is consistent with almost all our legislation. There's an element of discretion to determine the seriousness of the infraction and whether the fine is proportional to the infraction. So if it is said as this is the amount, whether it's 10% or it's 100 rand or whatever it is, and it leaves no room for discretion, we believe that may lead to unfairness. And then penalties should also be imposed, and this is a very important principle. Penalties should only be imposed by a court of law, only if an employer has been found guilty of an offense. Now, with these principles, Chair, we then make the following comments or submissions. Let's go to the next one. In respect of section 39, notice of an accident to the commissioner, so it's proposed that an employer, excluding an employer referred to in that section that fails to comply with subsection 1, shall be liable to a penalty of 10% of the declared annual earnings of that particular year. Now, according to this, a penalty at a fixed rate of 10% will be imposed if an employer fails to report an accident to the commissioner within 7 days after having received notice of an accident, or having learned in some other way that an employee is met with an accident. Chair, we do not agree that penalty being fixed at 10% of an employer's declared annual earnings is appropriate or it's fair, right? And that's where that discretion comes in. We think this is disproportionate to the harm caused by failure to report, and regardless of the reason. Therefore, fixing the amount in this manner, we believe, will only become a deterrent to employment and in fact, it is irrational. That's the next one. So again, we make the point that under Section 39, that a penalty should only be imposed by a competent court of law, and that the penalty should be phrased as, to give discretion up to a maximum of rather than 10% fixed. Thanks. Next one. In respect of Section 47, sub 3, paragraph C, Chair, this is a compensation for temporary or partial disablement. The bill proposes that an employer who fails to comply with paragraph A shall be liable to a penalty equal to double the full amount of 3 months compensation plus interest. Now, a penalty of double the full amount of 3 months compensation plus interest will be imposed if an employer fails to pay an employee compensation for the first 3 months of from the date of the accident. Our view, we don't agree with this. We think that any penalty imposed in terms of Section 47 sub 3 paragraph C should only be imposed if an employer is found guilty of an offence by a competent court of law, and that the amendment should be as follows. To be consistent with what we said before, an employer who fails to comply with paragraph A shall, if found guilty of an offence, be liable to a penalty of not more than double the compensation payable for a 3-month period. Close quote. In Section 72, sub 3, conveyance of injured employee, the bill proposes that this be amended as follows. An employer who fails to comply with subsection 1 shall be liable to a fine equal to the full cost of conveyance. Our proposal here, Chair, is that it should read, any employer who fails to comply with subsection 1 may be liable to a fine of up to a maximum of the full cost of conveyance. Thanks. Next one. So on the substance of the bill, Chair, those are essentially our submissions. And in conclusion, I should say that we, without stating the obvious, that we've represented the voice of business at NEDLEC, but the history of, or rather background to this bill is that in 2018, the NEDLEC task team concluded its deliberations on the amendment bill, and the NEDLEC report was signed by social partners in May 2018. And BUSA notes the following agreements, which were reached by the task team, emphasizing the need to abide them. One, that the amendment bill incorporating public comments should be submitted to the Department of Planning, Monitoring and Evaluation to undertake a CS and to assess the cost implications, in particular reference to the cost of implications for employers. The second area of agreement was that if any or after the public comments, that the amendment bill would be revised to incorporate those public comments and then be sent back to NEDLEC or retabled at NEDLEC for further deliberation before it is finalized. Chair, these we believe, in addition to some of the other areas where we say an agreement at NEDLEC said one thing, but the bill before you says something else. We believe that these areas where there's been a failure, if you like, to abide by agreements reached at NEDLEC has the potential to undermine social dialogue in a big way, because it means whatever social partners labor, for weeks and months on, and finally reach some agreements, it can just be undermined like that to stroke of a pen. We don't think that's the right spirit, Chair, and we think there should be respect for the NEDLAC processes. But that said, Chair, let me once again express our appreciation as BUSA for the opportunity you have given us to come and share our concerns on these two bills with you and the honorable members of this committee. Now, I am not alone, Chair. As you've noted, there's Sino with me, but there are also other members more eminently qualified than me to answer some of the questions you might have on both of these bills. So I will, with your permission, Chair, I have not introduced them, but I know that they are on the call. I've got, for example, Jonathan Goldberg. I should also be having Siobhan Leyden, in addition to Sino and myself. There may be other members of BUSA with me who may be on the call that I haven't seen, but we will all attempt to answer any of your questions, Chair. Thank you.
Thank you so much, Mr. Mayane. Thank you also for introducing the delegation. I know Mr. Goldberg. I don't know if he still stays in East London. He was my homeboy. Yeah, thank you so much. I think the process now is that we're not going to have a discussion on the presentation because of the process is that we will allow the Department of Employment and Labor to respond to in writing to the issues that you've raised. So what members are going to do now is to ask questions for clarity, not questions for debate. We'll debate after the Department of Employment and Labor has also put their position, but together with other stakeholders that are still going to present. So that is going to be the process going forward. And let me take hands for now. I see Honorable Protestant. You can go ahead, Honorable Protestant.
Thank you, Honourable Chair. Chair, if you don't mind, I've got very poor bandwidth, so I'm not going to turn the camera on. Okay. It's just a very simple question, Chair, to the presenter and his team. I apologise, sir, for not getting your name up front. In your presentation, you refer a lot to irrationality, irrational decisions, things that are unconstitutional, that may not pass constitutional muster. So the question I want to ask you, which I'm sure would greatly help the committee, is if these bills are passed as they currently are, do you think they will face legal challenge? And do you think they will face constitutional muster? If we could just get your opinion on that, that would be most useful. Thank you.
Thank you so much, Honorable Protestant. Are there any other comments on any of the two bills? Honorable members? Okay, looks like. Can I just also maybe have a bite, Mr. Moyane and the team, on the employment equity? You were referring to section 15A in capital letter. I think in another presentation, you were saying that the point that is being raised by Honorable Protestant about the constitutionality, and that you proposing that that section should not be approved by the committee. But I also noticed that you indicated as you were presenting that you yourself as a BUSA, for example, under section 15A in brackets, subsection 2, it says the minister may, after consulting the relevant sectors and with the advice of the Commission, for the purpose of ensuring the equitable representation of suitable qualified people from designated groups, and so on and so on. You were saying to us that that was your proposal that was also accepted by the National Assembly. How I mean that section, that subsection, then is part of 15A. The confusion on my side is that you say 15 in its entirety must be taken out because it won't pass the constitutional muster. Yet you yourself, you came with a proposal with regard to that, which was also accepted. So are you saying, therefore, including the proposal that you've made should be taken out of 15 subsection 2, section 15A? So I just wanted clarity with that. And then with regard to the section 53, just want to check, because already section 53, as you also indicated, that is already there in the Principal Act, except that your concern is about the insertion of subsection 6, particularly 6D and 6E. And as a result, you say that will be unconstitutional. What is it that will be unconstitutional? Is this D and E that could form the basis of this bill, if passed, not being constitutional? Because the other sections are already there in the Principal Act. So would only just D and B on their own make this bill unconstitutional? I just want to clarify, because you keep on referring to the issue of the state contracts, and the state contracts are already in the Principal Act, and there's no amendment with regard to that particular issue, except that with regard to the certificate of compliance, there are these additions which is 6 and subsections. So I just wanted to check that. But also there's a proposal that you were also making, just because your presentation is no longer the issue of sorry, I just want to go back to, because I'm still on COIDA. There was a proposal that you were making, or which says whether or not the employer has taken reasonable steps to achieve applicable sectoral targets. So on the other hand, you agree to the issue of sectoral targets. So that's why you're making that proposal. But on the other hand, you are against the sectoral, because there's that confusion. The proposal that you made in section 15A capital letter, subsection B, you part of the issue of sectoral targets. But again, you would say the section 15A is unconstitutional. And then again here on section 42.1, you are proposing that a section which says whether or not the employer has taken reasonable steps to achieve the applicable sectoral target. So meaning that you agree with sectoral targets, yet you say you must take away section 50. These are just clarity. I'm not debating, because I want to be clear as a committee when we deal with this. But also on the same proposal of whether or not the employer has taken reasonable steps to achieve the applicable sectoral target. What is the difference between what is being proposed in Bill in B14B under Section 53, 6D? Sorry, B, 6B, which says in respect of any target with which the employer has not complied the employer has raised a reasonable ground to justify its failure to comply as contemplated in section 42.4. So what is the difference between what you are proposing and this particular section? Because if somebody could say that your proposal is accommodated with regard to section 6B. So that's why I want to check what is the difference between what you are proposing on 42.1 and what is contained in section 53. But also, with regard to the proposal in the bill, there are specific areas that are identified for compliance. So it's not vague. But then with regard to the proposal that you're making on the steps, how do you measure reasonable steps? Because they are not articulated to say these are step 1, step 2, step 3, step 4, and therefore we'll be able to know that the employer has taken reasonable steps to achieve applicable sectoral, because they are not they are not outlined what sort of reasonable steps you're talking about. I don't know if you get the point I'm making. Unlike with the bill itself, the bill has specific areas of compliance, but your proposal only talks about reasonable steps without exactly saying which steps are you talking about. What is step 1? What is step 2? That you will then judge whether reasonable steps have been taken to achieve this target. So I just wanted clarity with regard to those areas. Thank you so much. I don't know if there are any other members who would like to ask questions, but if not, then I will go back to you, Mr. Moyan, for responses by you and the members of your team. Thank you.
Thank you, Chair. I was writing furiously as you kept saying, and then, and my hand was sweaty. So if I have missed some things, I'm hoping that my colleagues will pick up on that. But let me start with the point. As obviously we're not you're asking questions for clarity. We're not arguing whether what we are saying is appropriate or not.
Yes, yes.
So shall I start with the question from Honorable Member Bradison. Will the bill pass legal challenges or constitutional muster? I think for us as BUSA, because we participate in NEDLAC, it means we are interested in seeing that whatever policies or legislation comes out of NEDLAC that we have participated in should have general support amongst all social partners, because then it means it has a reasonable chance of being implemented without a glitch, right? But where we have obvious concerns about legislation, I think we owe it to our members, in fact, we owe it to the country to point those out. This is not the first time that we have pointed these out. We have indicated that don't accept this, and we think it is the wrong way to keep pushing. There are good things about the bill. We said the intention, we can't fault it, seeking to drive transformation in the workplace, and that's what we also want that. But we said the way that sometimes the bill is going about it is not legally sound, right? So we don't want to necessarily raise legal challenges where it's not warranted. But we do think that where a bill imposes what we see as quotas, which would then be in conflict. In fact, this would be if that section is understood, that section 15A is to be understood as imposing hard targets, as if there were quotas, it would be in conflict with section 15.3, right? But it's only if it is to be understood as imposing hard quotas. Now, sector targets does not mean that because we agree with them, we agree that they should stand as quotas. Okay. We understand the need for sector targets in consultation with the role players in the sectors, because they will bring in elements that may not necessarily be or that the government might not necessarily be familiar with, that impacts the levels of employment or transformation in that particular sector. So we said we agree, and this I'm talking to your concerns, Chair, about why do we agree with the targets then if we still have a problem with Section 15, right? We said what the Department of Labor, Employment and Labor, and the National Assembly seems to have agreed or taken on board, which was our proposal. In fact, it was not just our proposal, it was the agreement at NEDLIC, was that sector targets can only be set in consultation or after consultation with the sector players, right? That is what was missing in the bill that the National Assembly was considering. It said that the minister could set sector targets. It did not have any reference to consultation with sector actors. So, and that is what we had a problem with, because it was changing the agreement at NEDLIC. And then we welcomed the revision to revert to the NEDLIC agreement that sector targets can only be set in consultation. So that's what we agree with. Now, we're saying also that if you then interpret those sector targets as if they are quotas, and the quotas, if you say employer X, you have not met your targets, meaning you haven't employed 100 or 1,000 Black people, right, or Africans like that, which is your sector target. Therefore, you have not complied with the law. We say that treats that target as if it's a quota, and then it will be unconstitutional. And to that extent, it will be challenged. So we are not against sector targets, right? We need to be clear about that. We're just against sector targets being treated as if they were quotas. And then we say further that if you then go to the Constitution 217 when it deals with procurement, because ultimately this is about procurement. If a Section 53, meaning you can't do business with the state, so state can't procure services from employer X because employer X has not employed 1,000 Black people as it was a sector target, right? We're saying if you treat it like that, then you run the risk of falling foul of that section as well, right, of the Constitution. Now, but we also made another point, Chair, that whilst we're not against, in fact, I don't think that anyone in BUSA or any of our members would say that it's okay for a company to discriminate against its employees. No, we don't want that. Which is why BUSA was party to the changes in the law that gave the CCMA the powers to deal with disputes about unfair discrimination. So because we understand you need an adjudicator, independent, to tell you where you have gone wrong and to impose a necessary or reasonable remedy, because there are processes for that. Right? So those changes to the Employment Equity Act and the powers in the Labor Relations Act, BUSA was party to those changes at NEDLIC. and we're fine with it. But what we are not fine with, Chair, is for the Ministry of Labour to say, that's okay, but we also want to punish you again, even though you might have a dispute at the CCMA, we will still punish you when it comes to contracts, right? With government. We say that's irrational. It does amount to double punishment, and it's unjustified. And so I'm hoping that I've dealt with a number of your concerns, Chair, because you were saying we seem to be agreeing to some things, but almost as if we're contradicting ourselves. No, we are not contradicting ourselves. We are quite clear, Chair, that targets, rational targets set in consultation with the sectors are fine. But when it comes to assessing those targets, this is another point of clarity that you sought. When you assess those targets, you don't assess the targets by saying, look, you were supposed to, your target is 1,000 Black people. You only employed 999, therefore you didn't meet the target, right? That's not assessing. So we're saying when you assess our compliance, assess what reasonable steps we have taken, right, to get there. You ask the question, what are those reasonable steps, Chair? And I would like to believe that you know exactly how Section 42 looked like before it was changed, right? It had all these provisions. When it came to assessing compliance, everything was there, right? And BUSA argued that we should retain those things because they gave clarity to parties, right, on what it is that needs to be looked at when you assess compliance. But it was, as we know, and that's why we're here, we were arguing, those provisions were removed from Section 49, and we don't know whether they, you would still have this question if those were retained, right? But that aside, when we say look at or assess us by looking at the reasonable steps we've taken to meet the targets, we're looking at, things like, so, and there may many, each sector may be different from the next, but each company will have to, you'll assess it according to whether it's got access to the skill, the pool, what steps is taken to do training and to recruit from the, and so a number of HR processes that it is undertaken to try and meet those targets. Those are all relevant in assessing whether a company has taken the right steps to meet the targets or not, right? And you'll be assessing the right thing rather than whether they've met the target as a quota or not, right? I'm hoping that that gives some clarity, Chair. If I have missed anything, maybe at this point I could ask my colleagues, including your homeboy in East London, to come in. Johnny.
Honourable Chair, honourable members, and all participants in this hearing, thank you very much. I think my colleague has summarised it very well, but in a nutshell, the questions that have been asked, it's really the application in Section 15A that's important. So if you set those targets in consultation with all sectors and everyone agrees with them, you'll have a wonderful progression towards employment equity targets over the next 5 years. And that's always been our wish as business, is that we have something that's agreed on, we can buy into, and we can really achieve something substantial over 5 years. Section 42 is critical, though, in respect of how one applies that, and the default that if you don't get those targets, what actually happens, and that's written in the law, Section 42. It's not stuck away in Section 53, which is subject to minister or minister's delegated power. So in fact, an inspector could decide whether you've reached your targets or not, and that would mean no business for that particular company and potential closure or job losses. In a nutshell, Chair, just to summarize, I know we've taken a long time of your time, members, I think that is the big issue. And of course, added to that, they've got a double jeopardy issue potentially with now being fined or having to pay a person. Example, I discriminated against a female in respect of pay. I got an awarded adjudication against me in the CCMA. I accepted that. I accepted I was wrong. I restore pay the money back, pay to the employee, and we go on with our life. I'm now forced to appeal that because effectively, if that's against me for the next 3 years, I won't get a compliance order. Just to put that in a practical example. And then the honourable member's question about the constitutional challenge. I think if this does amount to an absolute bar, then one should read the recent constitutional court case, which I'm sure some other members here will be speaking to later on. And the reference is constitutional court case, which came out last week, CCT 279/20. I think that constitutional court case has a direct bearing on what my colleague has spoken about. Thank you very much for the time.
Thank you very much, Mr. Colbert. I don't know if Mr. Moyane want to do some closing remarks.
So, Chair, thanks to my colleague, Mr. Goldberg, as well, and to the other supporting members on the team. Chair, I think we have said, and hopefully we have highlighted the critical areas that we would like this committee to focus on, understanding that we are all for transformation, and we just want it done the right way, particularly where we can avoid any unnecessary disputes. That's where we should all be focusing our energy on. So thank you, Chair, and we wish you well with your deliberations. Thank you.
Thank you so much, Mr. Mayana and the team. As I was indicating that we were just asking questions for clarity, so we're not engaging and deliberating for now. We will set a date for the Department of Labor to come back and respond to some of the issues that you raised, including those that you said there were agreements that were concluded at a network level, but you find that they were now not forming part of the bill. So I'm sure the department then will respond with regard to those. I don't know if the legal unit would like to make comments at this stage, and also the Office of the Chief State Law Advisor, before we go to the next stakeholder.
Thank you, Chairperson. Suan Isaac from Legal Services. Chairperson, we also usually comment after the department commented. So we will come in at a later stage once we hear all the submissions, if that's you.
Thank you so much.
Maybe just one point, Honorable Chair, my apology.
Oh, okay. You can go ahead, Honorable Mima.
Yes.
We were at the stage we were finishing with the first stakeholder.
Yeah.
Yeah, you can come in.
So that I must not be unfair to BUSA during the deliberations.
Yeah.
Am I correct to say that BUSA definitely want to benefit from state contracts, but they have the challenge with the state strengthening its hand in terms of fast-tracking transformation, particularly to accelerate the empowerment of the historically disenfranchised people, because this intervention, my understanding is that it's informed by the progress that we have made in the last 27 years, the challenges that are continuing to engulf the sector. Am I wrong in making that assumption? Thank you, Chair.
I don't know if that won't be construed as a question for discussion rather than for clarity.
We're happy to respond, Chair.
Or you like to respond? You can go ahead, Mr. Muyan.
Sure. I mean, the honorable member is asking whether his assumption is wrong. I think the answer is yes, his assumption is wrong. We have said from the beginning that we are not opposed to the intentions in the bill when it comes to promoting transformation. We just want it done in a way that is not legally questionable. We said that the issue of quotas is, in fact, there's an express provision in the Act, Section 15, subsection 3, against quotas. We're saying if you then implement the sector targets as if they were quotas, it would be in conflict with that section. So we're not opposed to transformation. We're just saying it, let's do it right. And we've indicated areas where we feel that the proposed changes are irrational. And we would just like to make sure that those are excised from the last, from the final product chain. Because as I said, we at BUSA, we participate willingly and wholeheartedly at NEDLEC so that we can come up with pieces of legislation that are implementable, that will help us present our country as a destination for investment, right? If we've got laws that even we ourselves are unhappy with, that we end up at court fighting every day about, which investor is going to come in here when they're faced with that. So we would like to avoid all those things, Chair, by making sure that the laws that we have, promote the objectives that we want, promote fair adjudication of disputes in a consistent way and clarity, and then ultimately promote employment and investment chain. So honorable member, I think hopefully I've given clarity to that. The assumption was in fact incorrect. Thank you. Thank you, Chair.
Thank you so much. As I indicated earlier, that we're done with BUSA. We'd like to thank you for responding again to the advert, and also for indicating that you would like to come and do oral presentations. And also we thank you for responses to our questions. You are free to leave, but also if you want to continue staying to listen to other stakeholders, you have a choice. Thank you so much. Thanks. Bye-bye. Can we get Madia, can you assist the next stakeholder?
Yes, Chair. The next stakeholder is from the Banking Association of South Africa. So I see we have given them co-hosting rights, and I see they already started projecting. The delegation is led, from my understanding, by Ms. Bongiwe Kunene.
All right. Over to you, ma'am.
On the platform.
Thank you very much, Honorable Chair, for the opportunity that you have given to BUSA to also comment on the Employment Equity Amendment Bill. We only have this piece of legislation to comment on. We will not be touching on others.
Yes.
Honorable members, before I say much, I just want to reference to who we are. In BUSA, we represent the interests of all the banks that are licensed in South Africa. And those banks are licensed by our regulators, the Reserve Bank, the Prudential Authority, and the Financial Sector Conduct Authority in the main. And our purpose, therefore, is to interact with you on behalf of the industry to make sure that banking in South Africa remains sustainable, profitable, and better able to contribute to social and economic development and transformation objectives of the country. As I go on with my presentation, we can go to the next slide. I just want to start by making an assertion first that as BUSA, we are totally committed to transformation. And our members support the intentions of this bill, which is to accelerate transformation in the economy of South Africa. On our own, Chair, we have the transformation report, which we publish annually. And we do that to make sure that everyone who follows our agreements, which are captured in the Financial Sector Code as amended in 2017, can see transparently where we are, and we could have open conversations and debates on how we are handling the transformation part of banking in our country. So going on, we also have an environment, a legislative environment, which was passed by this parliament. And the biggest act that we comply with is the Financial Sector Regulation Act. It encapsulates all layers where we have to comply. And if you look at Section 28 of the FSRA, you would see that in performing any function with regard that will have implications on the activities of the financial stability of the country, and which will provide assistance to the Reserve Bank and the Financial Oversight Committee, which is the apex of all the regulators of banking. There is a need to maintain and restore financial stability as set by the Reserve Bank and the Financial Oversight Committee at all times. Therefore, Chair, my submission today will just seek to provide information on how certain provisions of the bill before you will have an impact on financial stability of the members of the association. And we would like to make a few proposals for the changes that can be made into the bill. Those proposals, Chair, they start from the apex, which is financial stability, because we've got different category of members. We've got 6 banks in South Africa where the governor of the Reserve Bank have pronounced in consultation with the Financial Stability Oversight Committee. And those banks are the so-called systemically important banks, meaning that in terms of regulation and stability of the banking services in South Africa, they carry the weight of what happens in the country. Then we've got a number of banks whose licenses put them in different categories, whether they're mutual banks or others. They come in different categories. But also, Chair, we've got international banks which are licensed to operate in South Africa. What is important, Chair, is that the FSRA makes provisions for fines and all matters that regarding what would be deemed as finable by the members of the banking association. So in order to maintain, for us to be able to maintain stability, looking at the fines relating to targets, the first point to note, Chair, is that they will most likely negatively affect the members, not just as they stand, but as they comply to the FSRA and also comply to international regulations as they relate to the environment, the social, and governance objectives. These have become very important given to the COP26, which we signed to last year, and different environmental concerns, which South Africa signed to, maybe even the ones which we hosted as South Africa. There have been a series of these, and we are compliant internationally. So, Chair, in order to maintain financial stability, insofar as the fines and all the facts that contribute to what makes a fine, if there is any conflict or potential for conflict with the FSRA, we would like to put it to you, Chair, that the provisions of the FSRA be given preeminence and precedence. And it's not just on our say-so, but we would also like you, Chair, to also consider what the regulators of the finance sector would say in this regard. Going forward, I would like now, Chair, to just look at the provisions of Section 15A of the proposed bills. I will not touch on A, 1, and 2. I will start only on Section 15A3, which gives powers to the minister to set targets in consultation with the National Minimum Wage Commission and not the relevant sector. BUSA has given an input in this. So, Chair, I would like to have BUSA comments to be seen as in support of all that BUSA has given, and these are additional comments. The first additional comment, therefore, Chair, is our participation as BUSA in NEDLAC. In NEDLAC, we have signed to the way in which the consultation processes work. And the processes that we have signed to start with the consultation with relevant sector bodies when setting sector targets. And the provisions of the FSRA, Chair, would say that financial stability needs to be taken into account when taking into consideration what would be targets and also what would be penalties. Furthermore, going into Section 15A4, notice has been issued in terms of subsection 3, which may set different numerical targets for different occupational levels, subsectors or regions. Now, Chair, what is really problematic about this, insofar as banking is concerned, is that the banks have got a national footprint. So if you start delineating and creating subsectors within the banks or targets which align to particular regions or sub-regions, it's very possible that you may have conditions applicable or provisions applicable to a number of provinces, but not to all the provinces. Or you would have targets that set the business in such a way that you have not just an administrative burden, but you've got difficulties in compliance, because this will speak to how you exercise your banking license in the country. In terms of how the banks are licensed, you don't have a way of differentiation, because once you have its one license, it gives you opportunity to practice banking in terms of the banking codes right across South Africa. Therefore, if you've got regional targets, you are introducing a layer of compliance which is not foreseen either in the Banking Act or in the Regulation Act. Therefore, you would need to start restructuring how the business of banking is done, and you will have to create monitoring mechanisms which are different per region and per subsector as what may be deemed applicable by the minister. And that would conflict depending where you are sitting in a particular province in the country. So furthermore, Chair, going forward, next slide, please. There will be unintended consequences. The first one, it is a function of all South African banks to fund the state whenever the state issues its bonds. All banks participate. And those that participate could be local, could also be international. Now, in the event that you have a particular bank failing to meet targets that are set in the employment equity bill, you would then have a regulatory burden which says this bank can no longer participate in funding the state. This, Chair, is outside of the procurement that a bank may want to bid for, that the state proposes or puts out. This is a function where all banks have an obligation to buy government paper. And if there's suddenly a regulatory obstacle, they will not be able to do that. In alignment with what BUSA had stated, there will also be another unintended consequence if the targets are hard-coded. Because what would happen in correcting any failure to meet the hard code is that what normally happens with time periods when you are complying to legislation, you would now have a new unintended risk for the banks in the sense that asset managers who evaluate how to invest in the banks as they are listed in the JSE and also in the stock exchanges across the world, they would be looking at this and saying, but these banks are not in compliance with a particular section of South African law. And there will be either a withdrawal from participating in the stock exchange by those asset managers insofar as they allocate their funds to South African assets, or there will be a complete blockage in the way in which they participate in funding the South African economy. Now, for an individual bank, Chair, the implication of hard quotas is retrenchments that would be trying to comply with hard codes. In this case, Chair, let me just speak of crucial sectors. If there would be an intention, this is an example, which says raise the number of non-white people in this subsector. The inverse of that is cut the number of white people in this subsector. If it doesn't say that, Chair, if it says cut the number in this subsector in this region, the inverse or the compliance effect would be banks cutting those numbers in that particular province at a time, Chair, when most of the banking functions are happening digitally. Right now, the numbers, if you look at employment of people in the banking sector, they are rising at a proportionate level, and it's not wholesale employment because most of the work is being done digitally. So this is an unintended consequence which would be the addition of retrenchments per category, subsector, and region or sub-region. Next slide. We also have concern, Chair, that the impact that this will have on hard skills or specialized skills, because it takes a little while to acquire those skills, is that within the sector, when you've got hard codes which are interpreted as targets, you will end up having a shortage of skills in banking for South Africa. As it is, most of the hard skills leave the country liberally because opportunities may be better elsewhere. And South African banking sector competes really well with the rest of the world. So in as much as we are building the skill sets for ourselves and there is an imposition of new targets, you may find an exodus of skills in the targeted subsectors. I've already spoken to digital ways of banking. So my last point on the concerns on automation and efficiencies, I'm not going to dwell on because I've spoken to the headcount and the impact of digital journeys that each of the banks is in. So, Chair, it's possible for us to do a detailed submission. I just wanted to highlight these 5 concerns. Going forward, in the next slide, our recommendation, Chair, is that we would like the setting of targets to continue being consultative, because we are not against targets. We would also want it to be transparent and to be evidence-based and to be in a forum where we've agreed on how we will deal with these issues at NEDLEC. We would also like the minister to continue consulting individual sectors before hard coding any of the targets to make sure that our concerns have been taken on board. Regarding the timelines, Chair, for us to be able to comply with the targets, we think that a period of 5 to 10 years would allow for adequate time to increase the skills base and to offset the unintended consequences that I spoke to earlier. Chair, we know that there will be a moment for debate. I am not here alone. I am here with a team from BUSA. If there are questions, I would like to invite my colleagues. There will be Thabo Mokoena, and Margaret Jacobs, who will be with me in answering your questions. Thank you very much, Chair.
Thank you so much, ma'am, for the presentation. I see Honorable Dango already has his hand up. I just wanted to correct something in your presentation, ma'am. When you're talking about the minister consulting the National Minimum Wage Commission, I think it is the first few pages of your presentation. It's not the National Minimum Wage Commission, it's a commission for employment equity.
Thank you, Chair, for the correction.
All right, thanks. Honorable Dango, I see your hand is up.
Yeah, Chairperson, thank you very much. And thank you for the Banking Council for having made such a broad presentation. But in having made such a broad presentation, they've opened themselves up to many more questions than this the question of what we are dealing with today. I think we need to say that with digitization, we are seeing branch networks closing, that people are becoming unemployed. Have they been redeployed by the banking sector? Are they re-employed? Are they de-skilled? Because of the new digital age, people are working from elsewhere and they're working digitally and not from a branch network any longer as such. That's one point. Chair, I think we should have a special session with the Banking Council to deal with issues of banking beyond the traditional banks. That community banks are important to service the unserviceable or the area that they're not servicing at the moment. That the community bank projects that was there initially seems to have fallen off by the wayside. Because if we're going to get unbankable people into the banks and provide them with services, the traditional banks are not going to do that. Their risk analysis will not allow them to do that. And of course, they are the guardians and the safeguards of the depositors' money, which they will not risk very easily. But in America, something different happened. They took the traditional banks, invested in community banks, South Shore Bank, that created an Obama. But I think, Chairperson, having said that, maybe we should have a special session with the Banking Council, because the banks can provide a different kind of financing for those people who are outside of it, and I think we need to have a special session with them regarding those kind of matters. Thank you very much.
Thank you so much, Honorable Dango. Are there any other questions, honorable members?
Chair, I may have an interest. I was Nedbank's representative on the Banking Council 30 years ago when they started it. Thank you.
Thank you so much. Honorable members, I don't think there are any questions. As I was indicating earlier when BUSA was making a presentation, that all we'll do for now is to ask questions for clarity, but then we will also allow the department to respond to the submissions that have been made by and still to be made by the stakeholders. But I would like to ask the presenters that are going to come and present after BUSA, just to zoom in on the specific amendments that you would like to see in the bill, so that we're not very broad in terms of our input, so that you are able to assist the members when they deliberate and say, this is where a particular stakeholder has a problem, and this is a proposal that a particular stakeholder is making. That will assist the members. But when it's very broad, it's going to be very difficult exactly for the members to know what is it really that the stakeholder is concerned about, but also is proposing to remedy the situation. So I just want to inform the stakeholders that are still going to present that we'll appreciate if you can have all the clauses or the sections in the bill and comment on each one of them, whether your concerns, your proposals, so that we know that we are specific to sections rather than to be broad, because it's not going to assist the members if we are broad, so that when we discuss, we know that there's this concern with regard to section 1, and therefore we will then deliberate, and also based on the responses of the Department of Employment and Labor, and also the advice that we will be getting from the legal unit of Parliament, and also the views of the Chief State Law Advisor. So I just want to advise the stakeholders, also that due to time constraints as well, that we be specific with regard to the sections of the two bills that are before us. I'm not going to ask then BUSA to respond to Honorable Dango, because he was also not asking questions related to the concern, but broadly about the role of the banking sector in terms of its role and services in the communities. It's a matter that can be followed up at another platform, as he was also indicating that at some stage there should be engagement with the banking sector. Can I go back to you, Madam, again, if you any closing remarks? I have articulated the process going forward that will get the response from the department. I'm sure even with the broad input, they will also narrow it to specific a section of the bill as well.
Thank you very much, Chair. Honorable members, we would narrow it down to section 15A, 3 and 4.
Yes.
We did not put the proposals because we wanted to highlight the concerns. If the chair would allow us to give the proposal after today on the exact wording, we would be able also to do that. Thank you very much, Honorable Chair.
Thank you so much, Mrs. Kunen. We will then also share those proposals with the Department of Employment and Labor so that they can also comment on them. That will then assist us in our deliberations in future. Thank you so much. Thank you very much. As I was indicating, then it's if you would like to stay on and listen to other inputs from other stakeholders, you are free to do so. But if not, then you are also free to leave the platform. Yeah. Thank you so much. Ms. Matia, the next stakeholder.
Thank you, Chairperson. The next stakeholder is the Financial Intermediaries Association of Southern Africa. I see they are represented by Ms. Lizelle van der Merwe and Ms. Samantha Williams, and I see they are both on the platform, Chair.
Okay. Over to you, ma'am.
Okay, this is a correction. We will be represented today by Advocate Sandile Kualu, who is on the call and ready to present, Chair.
Okay. I'm glad somebody else will be presenting because your line was not that good. I hope the person will be presenting, the sound will be good. Over to you, Mr. Kumalo.
Good evening, Chairperson of the committee, members of the committee, secretarial staff, and legal officers of the committee. Chairperson, I noted your remarks. I noted that the Department of Employment and Labor is represented. So good evening to those people. Let me start by introducing myself and tell you why I am here. My name is Advocate Sandile Kumalo. I'm an advocate at the Johannesburg Bar. I am here instructed by the Financial Intermediaries Association of South Africa to make the presentation on their behalf. Chairperson, I've just lost you on my screen. I hope there's no glitch on your side.
You can continue. I don't know if you have been given hosting rights. Oh, yeah, there is your presentation.
Yes.
You can continue, yes.
Thank you, Chair. Let me just point out that I do have my other colleague, Ms. Atkinson, who will be sharing the slides as we go along. Chairperson, members of the committee, as I said, I'm instructed by the Financial Intermediaries Association of South Africa to come and present on their behalf. So thank you for the opportunity to allow the FIA to participate in these public hearings. The focus is only on the Employment Equity Amendment Bill, not the other bill. So the interest of FIA is solely on the Employment Equity Amendment Bill. And they are hoping that they will make certain contributions that will assist both the committee, the NCOP, and ultimately the National Assembly to come up with a piece of legislation that will work for everybody. Chairperson, let me just say at the outset that the FIA's approach is slightly different. The FIA appreciates that if government is pulling on one side and business is pulling on the other side, this thing will break. So the FIA's approach is to find middle ground in relation to the bill and the amendments that are proposed in terms of the bill. Chair, in accordance with the directions of the committee, the slides were sent in advance to the committee on the 16th of February 2022. So what I intend to do is not to go word for word through the slides, because I appreciate that you already have the slides, and at a later period, you will get a response from the Department of Labor. Thereafter, there will be deliberations on the representations that were made by various stakeholders. And this committee will look at all representations and come up with a solution that works for the country, because that's what everybody wants. Chair, let me just give you an outline of the presentation as it appears in the slides. As I said, I will not be going word for word through the slides. So this presentation is split into two parts. The first part of the presentation deals with the background and tells you what the Financial Intermediaries Association of South Africa is, who they represent, and what they are about. It also deals with the consultation that has taken place up to this point on the sectoral targets. They also express a view on whether there's a need for subsector targets to be put in this piece of legislation. They also deal with compliance, fines, and constitutionality of the bill in its current form. And in line with your instructions earlier, Chair, Part B of the presentation is Annexure A, and that is where the FIA proposes the amendments to the sections of the bill. The specific sections that the FIA proposes amendments to is Section 15, capital letter A, Section 20, subsection 2, Section 42, subsection 1, and Section 53, subsection 6. Now, I will come to those later in my presentation. Chair, the most significant proposal in terms of the bill is the introduction of Section 15, capital A, to the Employment Equity Act. Now, if you look at where that section is going to be introduced in the Act, it will be in Chapter 3 of the Employment Equity Act. And Chapter 3 deals with affirmative action. Now you can tell from where the Department of Labor and where National Assembly wants to put that section, that it falls under the affirmative action provisions in the Act. Now, that is important because it follows immediately after Section 15(1)(5). And the speakers before me have alerted the committee and indeed the Department of Labor to Section 15, subsection 3 of the current Principal Act, being the Employment Equity Act. Section...
Excuse me, Advocate Enrico, can you also move the slides, because we're still on the, because we're still on the,
Chair, let me explain my approach. As I said, I will not be going through the slides word for word, but maybe what I will do is I will direct the person controlling the slides to move the slides as I go along. At this stage, I'm still prefacing what I'm going to say and what appears in the slides. So I was focusing on Section 15, subsection 3 of the Employment Equity Act. And that section says, affirmative action measures referred to in this section include preferential treatment and numerical goals, but exclude quotas. What is not clear from the bill, Chair and members of the committee, is whether what is going to be introduced by Section 15, capital letter A, in the form of sectoral targets, is the same as what is contemplated in Section 15(3), where it deals with numerical goals. And the main concern is this, Chair. If it is something different, then why does the bill not say so? But if it is the same thing, if sectoral targets and numerical goals are the same thing, why is the same piece of legislation using different terms? So I wanted to highlight that, Chair, and put it out there because it will inform the rest of the presentation. It may be that what people are concerned with has already been catered for in legislation. But if what is being proposed in the bill is something totally different, the committee has heard many speakers raising a concern about quotas. And the question is, are sectoral numbers, numerical numbers, do they amount to quotas? Or are they the same thing as what is in 15.3 numerical goals? And those are some of the aspects that have to be clarified in terms of the bill. Chair, let me then go back to the presentation very briefly. Who is the FIA? It is a non-profit organization. It is registered in terms of the Companies Act. It has 1,700 member businesses. I can assure you, Chair, in your life, you would have come across an FIA member who would have assisted you with some of your financial products. FIA members are financial services providers, and collectively they employ approximately 45,000 people. So they are a significant stakeholder in the industry, Chair. And the benefits of the advice they give to the economy is they assist consumers with their financial needs, they help educate consumers, and advisory businesses are a gateway to entrepreneurship in the sector. So I could go on, Chair. The final point on this slide is this. The FIA is committed to transformation, acknowledges, as one of the honorable members has said previously, that things are moving slow. That's why the government is taking steps to intervene. And the government must, in fact, intervene. And the FIA supports interventions by the government subject to certain proposals that it wishes to make. So the FIA would like the government, I'm talking specifically National Assembly and NCOP, to consider the various proposals that it makes, and they appear in section B of the presentation. Okay, can we please move to the next slide? Sorry, I was told that I have to say it loud, otherwise the person won't hear me, Chair. Thank you. So on this slide, I will be very brief. The FIA is concerned that consultations that have taken place at the moment preceded the debate on the bill and the promulgation of the bill, and therefore would not comply with the Act once it becomes law, and would encourage the Department of Labor and indeed the Minister to continue with the consultations once the bill is passed, because it is only those consultations that will comply with not only the language of the Act, but also the spirit of the Act. And why is it important to consult with the FIA? That is set out in the slides as they appear there. And Chairperson, in the interest of time, I won't go through each bullet point because the bullet points appear in the screen. Next slide, please. Chair, in terms of section 15, capital letter A, subsections 2 and 3, the FIA differs with, I believe it's BUSA that presented previously, in that the FIA, in fact, supports the clause that makes provision for sectors and subsectors and targets that apply to each. And the reason for that is simple, Chair. A one-size-fits-all approach will not work because some sectors are concentrated in various regions and other subsectors have qualification requirements that are unique only to those sectors. The demographics may also be different depending on which region a particular business operates in. Chair, a simple example, you will find that some businesses are concentrated in Gauteng and in the Western Cape, and they are not so concentrated in the Northern Cape, for example. So when targets are set, we would urge the minister to obviously take into account not only the subsectors, but the geography and also the demographics of each region. So as we say in the last point there, we will refer to comments later on in relation to section 15A and section 20A. Next slide, please. As far as compliance is concerned, Chair, FIA's approach is similar to the approach of the two organizations that presented previously. And Chair, you posed the question and I will try to answer it as I deal with the presentation. FIA is not saying throw away the current proposed wording that appears in section 42 and section 53. FIA says retain the wording as it appears, but also make provision for situations where attempt is made to comply with the sector targets once they are established. In other words, Chair, compliance must still be measured in accordance with the sector targets, but the legislation must reward attempts to comply with sector targets. I will give you an example, Chair, and try to answer a question you posed earlier, because the question Chairperson asked was, but what does it mean when you talk about reasonable steps to achieve the targets? Chair, take a simple example where an entity employs 100 white males. And once the targets are set and say the targets say 50-50, whites and designated groups, the other 50. But only 42 vacancies are available. And if a business takes steps to fill all those vacancies with people from designated groups, then that business has taken all reasonable steps to comply with the target, short of course of firing all white males and making space for people from designated groups. So the idea here is, Chair, that keep compliance as it is, and the starting point must be, have you complied with the sector targets as they have been set? But if not, the legislation should make provision for compliance in the sense that you have taken reasonable steps to comply with those targets. And that should be regarded as substantial compliance with the provisions of the Act, Chair. So that in essence is what the FIA proposes, Chair. Can we move to the next slide, please? FIA represents regulated entities, Chair, and they have to comply with other pieces of legislation. They also have to comply with issues such as requirements in relation to entry. I will give this committee a simple example. Chair, I'm an advocate. Before I became an advocate, I had to pass LLB, then do pupillage, then write exams. Then only then am I allowed to practice as an advocate. In the farming sector, you may not have a similar situation, and in various other sectors, you may not have a similar situation. But in the financial services space, you're dealing with regulated entities where not just everybody can come in. People have to write regulatory exams before they can be allowed to provide certain services. They have to meet certain fit and proper requirements before they can be allowed into certain industries. And the regulator that regulates financial services companies has its own regulations that it imposes on these entities. So the proposal that the FIA makes is that in addition to requiring the minister to consult those sectors, where appropriate, the minister should also consult those regulators who regulate financial services companies, because doing so would ensure that there is no conflict between various pieces of legislation. And there is also no conflict between requirements set by one organ of state and another organ of state. So in a nutshell, Chair, that's what the FIA proposes. If I can then, in the interest of time, move to the next slide, please. Very briefly on penalties, Chair, no doubt this committee would be aware of the penalty provisions in the current Schedule 1 of the Employment Equity Act. The FIA is of the view that those penalties were set with different provisions of the Employment Equity Act in mind. If there are to be penalties that are applicable to sector numbers that are now set by the minister in terms of Section 15, capital A, once it becomes law, that should also form part of the consultation between the minister and various stakeholders, Chair. And that's the only way that you can then find the balance between these various pieces of legislation and the provisions in the schedule to the Employment Equity Act and the provisions in the Act itself. Next slide, please. Chair, on the constitutionality, I have already touched on this, but in the context of Section 15, subsection 3 of the Employment Equity Act. And the simple point is made there that it should be preferential treatment, it should be numerical goals, but not quotas. Because once it becomes quotas, not only is there conflict within the statute itself, but there could be constitutional issues that arise from that. Chair, can I then take you to Annexure A? Next slide, please. Proposed amendments by the FIA. Chair, the amendments that are proposed by the FIA are highlighted in red. And where FIA believes that something should be removed from the statute, you will see that it has been scratched out. The first proposal in relation to 15 capital A sub 2 is that the words after consulting should be replaced with in consultation with. Now, I should pause here because the two speakers before me use the terms interchangeably, Chair. You will recall at one point they said it means in consultation with and after consultation with. I will bore this committee because I'm a lawyer. I will refer you to a judgment of the Supreme Court of Appeal. It will be shared with the committee because it is important. It is McDonald against the Minister of Minerals and Energy, 2007, volume 5, South African Law Reports, page 642. In fact, it was a Cape Division judgment that was confirmed later by the Supreme Court of Appeal. Chair, there the court said the differences are not just semantic, but have important consequences. And at paragraph 18, it said this: where the law requires a functionary to act in consultation with another functionary, this means that there must be concurrence between the functionaries. So if you apply to this situation, it means there should be concurrence between the Minister of Labor and the various sectors that he's consulting with. Now, here is the important part, Chair. Unlike a situation where a statute requires a functionary to act after consultation with another functionary, this requires no more than that the ultimate decision must be taken in good faith after consulting with and giving serious considerations to the views of the other functionary. So the concern must always be that lip service is not given to consultation. Consultation must be a meaningful, inclusive process where both parties come together and reach agreement, if they can, on the sector targets. Because when that is done, there's no risk of litigation at a later point. But where this is done after consultation with the various stakeholders, then it means the minister could simply listen to them and decide that I don't agree with you, I'm moving on. Hence, Chair, the proposal that you see there, that in consultation with should be preferred to after consultation with. And we've also suggested then that where applicable, consultation also take place with the regulators. As far as 15A3, we've added in red there that where the sector provides sufficient reasons, such as difference in skills, the minister may set different numerical targets per subsector and per region. That speaks for itself. And the last one, Chair, sub 4, that the at least 30-day period be replaced with 90 days for obvious reasons, Chair and members of the committee. You saw how many business members the FIA represents. Obviously, if any draft is issued by the minister, the FIA would need to consult with its various member businesses, prepare a combined submission, and submit that submission for consideration by the minister. And 30 days is simply not enough for consultation at sector level before preparing a consolidated submission to the minister for consideration. And then with section 20 sub 2, not a big change made there, simply to delete sectoral target and say target, because here we are assuming that you would have accepted our proposal in 15A3, that the targets can be at sector level and subsector level. So those are the proposed changes suggested as far as 15 and 22 are concerned. Next slide, please. As far as section 42, again, Chairperson, similar proposals are made. So the target remains. And when you monitor compliance and you enforce compliance, the starting point must be, has the employer complied with the target? And if that employer has not done so, then the next step should be, have they taken reasonable steps to comply with that target? And I have explained the rationale for why it is necessary to have that. Because if you get to 99, but you don't get to 100, Chair, you've taken substantial steps to comply. But the current bill as it stands will mean that you didn't comply because you are below 100 and you are at 99. When for all intents and purposes, you've taken substantial and meaningful steps to comply. The next one is, of course, section 53. The previous speakers have spoken about it, Chair, and similar proposal is made to 53, subsection 6, which is being proposed. And there we also say one of the factors that should be taken into account when the minister decides whether or not to issue certificates is whether reasonable steps have been taken to comply with those targets. And we agree with the previous speakers that a business that has taken substantial and reasonable steps to comply with the targets and can prove that should not be left out as far as government business is concerned. They should not be disqualified from doing business with the government simply because they just came short, but they substantially complied with the targets that were set by the minister. So, Chair and members of the committee, as you can see, the approach the FIA takes is the middle ground, because the FIA appreciates that on the side of the government, there is a need for this bill and for this legislation. But on the side of business, there are regulatory hurdles and other business hurdles that may prevent businesses from fully achieving the targets set out. So we urge this committee, when it considers all the presentations, to find the middle ground so that you make sure that the bill and the piece of legislation that will come out of this bill works for everybody and works for the country. That's ultimately what we all want. Next slide, please. So, Chair, that concludes the presentation for the FIA. The FIA appreciates the opportunity to present to this committee, and they thank the committee for the opportunity to participate in what is a very meaningful process of participating in drafting legislation that will really affect various sectors of our society and various sectors of our economy. So, Chair, I'm going to stop there. I hope I did not exceed my time. I tried very hard to stick to 15 minutes and have at least 5 minutes for questions and clarification. Thank you, Chair.
Thank you so much, Advocate Kumar. We really appreciate the presentation, and also it's clear also in terms of the format, and also that you talk to the sections within the bill, which will then as I indicated earlier, I will assist the members because it's clear, it talks to a particular section, and then you comment, not necessarily that we agree or we don't agree, but we like the way that you structured. So, because you are an advocate, so it's easier for you to really structure it in terms of what is contained in the bill. So I will then use this time to allow members to ask questions, if any. So if there are no questions yet, Advocate, it will mean that members are clear with the presentation. They will wait for the department then to respond, and then they will then deliberate on the issues that you raise. Just for me, I just want to go back to the issue because I didn't hear BUSA responding to the issue I raised. It's the same issue that both of you are referring to, the issue of reasonable steps with regard to Section 42. My question is, if you leave that section as proposed in the bill, Section 42, as proposed in the bill, but then in Section 53, Section 53, 6B, let me read it because I read it earlier, that it says, in respect of any target with which the employer has not complied. I'm making then the example that you're making of the target would be 50-50, but then you achieve 42. Wouldn't the Section 53, 6B, subsection 6B, which says, in respect of any target with which the employer has not complied, the employer has raised a reasonable ground to justify its failure to comply, as contemplated in Section 42.4. Wouldn't that then address this reasonable attempt? Because then you will be saying, you come with your reasonable attempt argument, and therefore you will then be in line. Those arguments could be then be in line with Section 53, 6B. I just want clarity on that, because my worry with Section 42, the proposal that you're making about the reasonable steps. How do you avoid a situation where from time to time the department is taken to court because there's a debate in terms of what is a reasonable step, what is not a reasonable step? Shouldn't we rather leave it the way it's proposed in the bill? But then if you have attempts, reasonable attempts that you've taken, then they will be taken care of by Section 53, subsection 6B. It's a question I asked to BUSA earlier, but I just want to hear your view on that particular aspect.
Thank you, Chairperson. Here is the difficulty. Section 42 and 53 are standalone sections.
Yes.
So 53 does not cure 42, because the consequence of 42 could be that a fine is imposed because of non-compliance. That's why 42, as it currently reads, it says whether the employer has complied. So if it is found that you did not comply, then that's an act of non-compliance that could attract consequences independent and separate from 53 in the form of fines and penalties and other serious measures. 53 is only relevant to state contracts. So if you want a state contract, you can say to National Treasury or that entity, a certificate should be issued to me because although I did not comply, I still took reasonable steps. But that only assists you if you want a certificate and the government contract. It doesn't assist you as far as consequences of non-compliance with various sections in the Act. So if you don't comply with 42, 53 does not assist you.
Yes. No, I'm clarifying.
Because they stand alone, and Chair, I'm glad you raised this question. For the same reason that 53 makes provision for justification for non-compliance, 42 should also contain a similar provision. Because why should there be a risk of a penalty if there's good justification for non-compliance? Okay. And Chair, the last point, because you raised this, the same issues about minister being taken to court can arise under 53 even in its current form. Because what if under 53 in its current form, the minister says, I hear your justification, but I'm still not going to give you a certificate because I don't think it is a good enough justification. So there won't be proliferation of litigation as a result of what we propose. In fact, it will ensure that before there's a dispute between the minister and whatever the business that is covered under Section 42, there is this engagement where the business is able to show the minister, yes, I did not comply with the targets, but these are the steps I have taken to comply with the targets. And the minister can look at those steps, or whoever it is that is enforcing compliance can look at those steps and say, this is substantial compliance. So in a nutshell, Chair, we're saying the pass mark should not be 100. The pass mark should be anything above 60, above 50, but between that and 100, depending on the type of sector you are dealing with. So that if you have achieved 95% compliance, you shouldn't suffer the same consequences as somebody who has failed to comply at all. Because zero compliance and 95% compliance attract the same consequences. And that seems irrational, Chair. If a business that does nothing at all is still going to be fined 2% of its income, and a business that does 95% to comply is still going to be fined the same amount, it doesn't make sense. That's the point we are making.
Okay, no, thanks for the clarification. I don't know if you had an input on Section 53. I might have missed it. If you can maybe clarify it. Section
on 53, Chair, if we can have the penultimate slide, please.
Particularly D and E.
No, we only had input on A, Chair. Only A. We were only concerned with A, that the employer has complied with the numerical target set in 15A that applies to that employer or has taken reasonable steps to comply. Okay. So that was our only contribution. Okay. Chair, before I conclude, I did mention that I would like to share with the committee that judgment. In fact, it's two judgments, one of the Cape Division and one of the Supreme Court of Appeal that deal with the difference between after consultation and in consultation with. Because I believe that in the committee's deliberations, it will assist quite greatly. And if you consider the first speaker's presentation, many of the constitutional difficulties that were raised may in fact be minimized if these things are done in consultation with as opposed to after consultation with, because then you avoid future legal challenges. So we will simply share a slide that deals with that and also the conflict between 15A and 15.3, just for completeness. But other than that, Chair, that is the presentation on behalf of the FIA.
Can I rather suggest that that part be shared with our committee secretary, and then it will then be circulated to the members without you taking us through it now?
Yeah, no, Chair, I've already covered it in the presentation. So what we will do is we will simply supplement our slides by adding 2 pages so that the committee and maybe even National Assembly then has the benefit of those two judgments.
Okay, thank you so much.
Thank you, Chair.
Maybe just the last point, Chair.
Oh, okay. Honorable Kenny.
The aspect raised around reasonable steps. Because from where I'm sitting, the issue of reasonable steps could to a certain extent also be seen as a ground, as a justification for for continued non-compliance. Maybe if the team could also probably share to assist us in deliberations in terms of their understanding, what will reasonable steps entail as a reason for non-compliance. I hope I'm clear on that one. Thank you, Chair.
Thank you. Advocate?
Thank you, Chair. I think that was clear. So I understood Mr. Mujamang to say when we supplement our presentation, we should cover that aspect. But in a nutshell, Chair, it is substantial compliance. You can tell the difference between an entity that did nothing and an entity that took steps to comply. And I used an example. If there were 10 vacancies and a company filled all 10 or 9 out of 10 with people from designated groups, then you can tell that that company took steps that are reasonable to achieve their targets. But if you have a company that does the opposite, then you can tell from that that no reasonable steps were taken. And it will be obviously a subjective and an objective assessment that has to be done at the stage when the legislation is being implemented. But at the stage where legislation is being drafted, our contribution is simply to say, where you can see that there are going to be problems later on, rather fix them now, so that all you do is you leave to the minister to simply implement legislation, instead of getting involved in fights about what does this mean, what does this not mean? Because you're gonna run the risk ultimately that most businesses simply do not comply because the targets were excessive for them. But if you make room for the minister to make a determination that there has been reasonable compliance with legislation, then you have given the minister sufficient powers to implement this legislation and to punish those who deserve to be punished, but to reward those who deserve to be rewarded. You don't want a situation where most companies achieve 99% success, but because they did not hit the target, they are lumped together with those that do nothing and they are penalized in the same way. So that is really what we're saying in a nutshell. But if we need to develop that submission further, we will do so in the form of an additional slide, just to clarify only that point without over elaboration, Chairperson.
Thank you so much, Advocate.
Thank you.
I see there's a hand of Esma Kabeni. I don't know if it's part of your team. Advocate.
No, Chair, I thought it was part of the committee's team, so.
Can you introduce yourself, Mr. Makabin?
Thanks, Chair. I'm the State Law Advisor, Chair.
Oh, yes, okay.
Yes.
No, that's fine.
I just wanted to point the committee chair and the presenters to the provisions of the proposed section 53(6)(b). It cross-refers to 42(4).
Yes.
And section 42(4) says in any assessment, so section 42, its heading is assessment of compliance. So it says in any assessment of its compliance with this act or in any court proceedings, a designated employer may raise any reasonable ground to justify its failure to comply. So that's a provision that's already in the legislation, Chair. That is in existence. That
was a one that I was quoting, but then Advocate says it's a standalone section that deals with the state contract.
No, that one is under 42, Chair.
Oh, okay.
So it's 42(4), the current 42(4). Yes.
Or in the Principal Act.
Yes.
Oh, okay. Okay.
Thanks, Chair.
Thank you so much for that clarity. I don't know if Advocate want to comment on that.
Just briefly, Chair, again, if you look at subsection 4 in the current section 42, in assessing any compliance with this act or in any court proceedings, a designated employer may raise any reasonable ground to justify the failure to comply. So it is justifying the failure to comply. It's almost a defense. And our proposal does not deal with a defense to non-compliance. Because if what we are proposing carries favor with this committee, and to the National Assembly. Substantial compliance will be compliance with Section 42 and 15A and others. So if the minister has found that you've taken reasonable steps to comply, you won't need to go to 42.4, because 42.4 deals with a situation where you have not complied and you must now give an explanation why you did not comply. But if the act is crafted in such a way that the first thing you are required to do is to comply with the target or take reasonable steps to comply with the target, the minister can stop there and say, you didn't comply, but you took reasonable steps to comply with the target. And that's where it ends. So you don't need then to go to 42.4, because 42.4 assumes that you have not complied. And because you have not complied, you must now give a reasonable explanation why you did not comply. And we are saying if our submissions carry favor, it would mean that substantial compliance that did not meet the target qualifies as compliance with the act. So, Chair, it's that thin line that one must understand very carefully. And as we said, we propose that because we know that if we say take out the need to comply with the targets, then you incentivize companies or legal entities, and they won't comply because they will simply say, I've taken reasonable steps. So we're saying the starting point must still be compliance with the target. And then there's the option that, the minister can say, I'm happy that you've reached 90% and you have complied with the act, even though you didn't comply with the target.
Okay.
And I appreciate that question because I now see that it required clarification. So thank you, sir, from the State Law Advisor's side for raising it. And I hope I have clarified it. And to the extent necessary, we will clarify it further in the supplemented slides. Thank you.
All right. No, thank you very much. I don't want us to risk now starting the deliberations.
Lawyers can talk all day, so there's a danger that state law advisors and advocates can end up debating. Yeah. And we want to avoid that at all costs.
We want to avoid that, yes, indeed. Thank you so much, Advocate, for the presentation. And as I indicated, that we appreciate that your presentation was talking to the relevant sections in the bill. As I indicated earlier with other stakeholders, we will wait for the department response, but also take advice from the legal unit of Parliament and the state law advisor, as well as our procedural officer from Parliament. And after that, then we'll have a deliberation and vote clause by clause on the bill. And also adopt a report, vote on the report whether we adopt it or not. So that's going to be the process after all these other processes have been processed. We really thank you because when we receive this presentation from the department, some of these sections don't mean anything to us as members until they are contested. Then you start then going back also even to the presentation and also to these bills, the principal act, the bill, original bill from department, and also the B14B, so that you see what the A list from the National Assembly, what it says. So it assists once there are debate around these issues, the submission that you're making as a stakeholders, they really assist to enhance the debate. Otherwise, if they just a presentation from the department, sometimes they don't mean anything to us until there's this contest on the relevant sections of the bills. Thank you so much. As I indicated, then you're free with your team to remain, or if you have other commitments, you're also free to leave. Thank you so much.
Thank you, Chair. We will remain. I should just mention they are on the line, they are listening. They really do appreciate the audience. Thank you. And thank you to your committee.
Okay, thank you very much. Ms. Badia?
Hi, Chair. Next on the program is the Black Business Council for the Built Environment, led by Mr. Mofokeng.
Okay, over to you, Mr. Mofokeng.
Thank you very much, Chair. I hope I'm audible, Chair.
Yes, you are.
Thank you very much, Chair. Chair, we are representing the Black Business Council in the built environment. And with me, I have my colleague, Mr. Douglas Affleck. So it will be a combined presentation, Chair, and we will be focusing both on the employment equity bill as well as the COIDA. So I will be handling the first part, and Mr. Affleck will then handle the second part of the presentation, Chair. And once again, we want to thank the Portfolio Committee for giving us an opportunity to do our presentation as far as these two bills are concerned. May I just request the person who is manning the presentation just to get us to the next slide. That's the overview of our presentation, Chair. And let me just say upfront, Chair, that we are not lawyers at all. We are just mere contractors who are passionate about transformation in the construction industry. And therefore, our presentation will not be as detailed and as clinical and as technical as that of our previous presenters. So we will provide a brief profile to the committee, and we'll look, and then we will get into the two sections of the presentation, as I said. Next slide. We are the Black Business Council in the Built Environment, colleagues. We were established in 2007, and we cover the full range of the construction industry. Therefore, our members, Chair, and the committee are built environment professionals, so architects, engineers, quantity surveyors, and so on. We also look after the interests of contractors, as well as suppliers and manufacturers in the construction industry. So that's the coverage that we have as an organization. We also have an interesting composition because we represent member associations that represent sectoral interests, as well as corporates that join us directly without going through the member organizations. And when you look at that whole membership profile and the coverage, we represent in the region of about 5,000 companies. We are also Chair and committee members, honorable members, a member of the Black Business Council. Next slide. This is just to show the what we call the institutional alignment. The Black Business Council is our ultimate mother body, and we are the Black Business Council in the built environment. We take care of all the members who are in the built environment space, and we have other sister organizations such as the Black Management Forum, which I know most of the people are familiar with, the likes of UPSIP and so on. All in all, there are 52 member organizations that are affiliated to the Black Business Council. Under the BBCBE, we then have sectoral organizations, as I said earlier, and we've given you an example of those right at the bottom there. South African Women in Construction, SABTACO, which represents the consultants in our midst, emerging contractors and so on, and others focus, for instance, Chair, exclusively on lifts and escalators and so on. So these are sectoral organizations that represent sectoral interests in the construction industry value chain. Next slide. Chair, just to paint a little bit of context here is that we all know that the Employment Equity Act came into being in 1998. So it's been 24 years of implementing this legislation. And Chair, without fail, every year the Employment Equity Commission releases its report, and every year, we have even stopped changing the content of our media statement after the release of each and every report by the Employment Equity Commission, because every year we decry the state of lack of transformation, in the South African economy. So that's the reality that we are faced with. And over the years, we have lobbied long and hard, together with our sister organizations such as the BMF, to say that we need to have more tougher measures as far as employment equity is concerned, Chair, because we can't be doing the same thing over and over again for 24 years and expect a different outcome. So what it has, this period has demonstrated to us is a lack of goodwill when it comes from corporate South Africa. I think there's definitely lack of goodwill, because if there was goodwill, there will be no need for us to be introducing stringent measures as far as legislation is concerned, just to get our corporates to act accordingly. Broad-based Black economic empowerment is a key program of this country and of this government. So we need to see transformation happening, not only generally, but also in the companies that are operating in our country in the various sectors. So we have not seen goodwill for the past 24 years, Chair, and hence we have lobbied long and hard, for these amendments to come through. So we are quite excited about this amendments to the legislation, so that we can then, guide the actions of our corporates, because on their own they have not managed to align themselves with the objectives of our government to make sure that this economy is transformed and that Black people do enjoy participation as far as employment is concerned in the higher echelons of our corporates. So we are quite excited about this. From the onset, Chair, we must say that as the BBCBE, we fully support the amendments. And of course, our focus is on the construction sector. There has been engagements with the department, Chair, and in those engagements, we have made it very clear that we would like those sector targets to be set, and to even take it a step further for them to be quotas, so that we are all clear in terms of the targets that must be met by our sector. So we are in full support of that. And we have said that, the current prevailing targets in terms of the construction sector charter codes should then be the ones that are adopted as far as this legislation is concerned. It took us almost 24 months to negotiate those targets, Chair. And we think that we don't need to go and reopen the negotiations as an industry, because it will take us another 24 months or even more, to reach consensus on them. So we think that those, targets that have been negotiated, over that period can be the ones that are adopted for the industry. The next issue, Chair, which is the last point on this slide, before I also hand over to Mr. Affleck, is that we are concerned about policing, Chair, and this is a problem that we have across the board as far as government capacity is concerned. And our view is that the department does not have sufficient firepower to be able to police these regulations and their implementation. So we go about as an industry association, we receive a lot of complaints from our members that certain companies are fronting, that certain companies are not doing things the right way, but you find that they do get, if I have to use an example, the scorecards that we have, you'll find that some of them are level 1 or level 2 BBB companies. Yet, the anecdotal evidence suggests that they've done nothing to transform those companies. And we are very much worried about the ability and the capacity of the department to police, this new measures as they are introduced. And therefore, we are proposing that, there should be some kind of a partnership between the department and private sector associations like ourselves to see how best can we join hands in policing and making sure that, the reports that will be submitted by companies to the department are in fact a true reflection of what is happening as far as their internal mechanisms or mechanizations in the companies is concerned, so that we avoid fronting and we avoid a situation where people that are refusing to transform, are then barred from doing business with the state. I think the whole, approach of saying that, companies henceforth must get their clearance certificates as far as employment equity is concerned is a move towards the right direction. We think that people who do not want to transform, who do not want to join a government program of making sure that the economy transformed, should therefore not participate in enjoying the benefits of doing business with the state. For us, it's quite clear. If you want to do business with the state, you've got to align yourself with the policies of government and make sure that you assist government in achieving its objectives at the end of the day. So we are quite excited about that. We are also excited about the direction that we are taking as far as the fines are concerned, Chair. Of course, there's still some work that needs to be done in terms of ensuring that those fines can be meaningful, so that we avoid a situation where companies can actually budget for those fines, knowing very well that when they are caught out, they can pay the fines and still continue to do business as usual. So we're quite excited about this, Chair. And I think in the interest of time, Chair, let me then hand over to my colleague, Mr. Affleck, then to get into the second part of our presentation.
Yes, good evening. Thank you, Mr. Mofokeng. Thank you once again for the opportunity. Adjust my screen there. And good evening to the Honourable Chair. Good evening to the Honourable members. And thank you for the opportunity and the inclusion in this participation process. We do appreciate it as the construction industry and as the built environment as well. With the interest of time and with due respect, I hope I've absorbed all the protocols. And if I may, I'll move on to the slideshow. Right. So what I'm covering in two very short slides is a commentary on the compensation for occupational injuries and diseases amendment. The first bullet there, as Mr. Mofokeng's already mentioned, we are in full support of the amendments. We think they are made within very good context. We're very happy to see the improvements on occupational diseases, rehabilitation, inspectors' powers and involvements, and the expansion or the extension on the timeframes to finalize administrative work. It's great to see. We can definitely see that commentary from the industry has been taken into account, and we do appreciate that. The third bullet there, the definition of dependent has been updated to suit the South African context quite well. We're very satisfied with the broadening of that definition. However, in broadening the context, and with our migratory workforce in mind, it will create some challenges for the insurance underwriters and the legal aids to define who is most dependent, who is most relevant, or who is most bound to the person that was injured or passed away, and then how to fairly distribute those policy outcomes, how to cascade the outcomes, or how to justify the hierarchy of those outcomes. So as a suggestion, we would like to see the definition consider the broader legal context and give the industry and the legal aids as well as the underwriters some guidance on how we would realize those policy outcomes and ensure that the funds go to the right people in a fair manner. If I may have the next slide. Thank you. In terms of Section 18, the amendment for the Commissioner to have power to transfer funds from the COIDA fund through to the PIC for investment without the Director General's involvement is something that we're a little bit concerned with. As Mr. Mofokeng mentioned, we are construction contractors. We work in the built environment. We're not lawyers by trade. So there is a chance that these have been discussed previously or that these are clarified in other acts. However, the way we see it, the Director General should still play a role in the decision and should still take accountability for the investment of those funds. And the full accountability, or shall I say the full decision making, should not lie only with the Commissioner. The second point we have there, a license provided to FEM to conduct business on behalf of the Commission in the construction sector, it should be advertised for alternative and empowered players in the market to have an opportunity to tender for it. That's pure fairness. We allow for other insurance providers, particularly Black-owned businesses, Black-owned insurances, to be allowed to compete for the opportunity, the same opportunity that FEM is provided on an annual basis. And then the third point, that has become an administrative nightmare and costly for companies, particularly small companies. I'm talking in the built environment and with the experience in our smaller industry, to secure a letter of good standings. Work does not flow as smoothly as it does perhaps in the financial industries and in other industries in construction. It is a stop-start industry. It is an industry where when things get built, the job gets done, but when things aren't getting built, companies are charged these rates to secure, and in some instances, upon renewal, they have to go through an audit process, or there's an outstanding fee that they have to pay, which I can understand entirely from an administrative perspective. But what we're saying is there are smaller companies that just can't really keep up to this. This simply means that companies that depend on public sector projects are unable to tender for these opportunities. And we would like to see some revision, or at least some guidance, or a toolkit of some sort, perhaps, that accompanies this act, to give smaller companies an opportunity that perhaps haven't had business in a short while to still tender for the work, and thereafter get their letter of good standing in some way, whichever ethical and fair way that might be. Next slide. That's it. Short little couple of items from us. I don't know if there's any questions on COID. I'll be happy to answer those. Without putting words into Mr. Mofokeng's mouth, I think he'll be happy to answer any on the employment equity.
Thank you very much, Mr. Douglas and Mr.
Thank you, Chair.
Thank you so much. Honorable members, are there any questions on the employment equity and the COID bill? It seems that everything that you presented, Mr. Douglas and Mr. Mofokeng, is clear. Your presentation has already been shared with the Department of Labor, both the Employment Equity Amendment Bill, as well as your submission on that, and also on the COIDA. They will be responding on the issues that you have raised in the submission. And thereafter, members then will deliberate or have deliberations on the two bills. Thank you so much for your attendance, and also the presentation that you've made to the members. Thank you so much.
Thank you, Chair. Thank you.
Thank you, sir.
Thank you, Mr. Mofokeng. I'll keep on saying that you are free then to remain and listen to other inputs from other stakeholders. But if you have other commitments, you are also free to leave. I think it's the next one is SAIA. Let me just put it that way, or is it ACIS? Advocate Riaz, let's give it to you. You can also pronounce the name of your organization.
Thank you, Chair. Good evening, and good evening, honorable members. Thank you firstly for the opportunity to make this presentation and provide our inputs, also aimed at attempting to assist in refining what will become a set of amendments to the very important and transformative piece of legislation in the form of the Employment Equity Act. Our submissions will be confined to this act. We won't be dealing with COIDA as part of our submissions. Before I introduce the stakeholders on whose behalf I make the submissions, I should perhaps introduce myself first. I'm an advocate at the Johannesburg Bar, and the two stakeholders on whose behalf I make the presentation are ASISA, which is the Association for Savings and Investments South Africa, and I'll come to the detail of who their constituent members are shortly. The second is SAIA, the South African Insurance Association, and again, I'll come to the details of who their members are and what they do very shortly. The slide before you covers 7 broad topics, which I will address, but in broad terms, the presentation I'll make can be split into 2 parts. The first will identify what we perceive and have flagged as possible problems and risks inherent in the formulation of the bill as it currently stands. And the second part, because the aim of our presentation ultimately is to make constructive suggestions aimed at addressing those issues, will be the presentation of a package of proposals which are aimed at addressing the problems and risks that we have identified and will take the committee through this evening. Before I do that, I'll start briefly with who the stakeholders are. The first, as I've mentioned, is ASISA, the Association for Savings and Investments South Africa. It's a non-profit industry body which represents 119 members of the savings, investment, and insurance industry. The members of ASISA collectively manage a huge amount in Rand terms, 7.2 trillion Rand on behalf of clients. And when one talks about clients, that includes the South African public. They paid 840 billion Rand in insurance claims during COVID, and I identified these figures really to highlight the role that these stakeholders play in the economy. And as I develop our presentation and submissions this evening, also the extent of the risk of some of the amendments if it impacts adversely on the members and stakeholders on whose behalf we address you this evening. Also significant perhaps is the fact that ASISA's members manage a large portion of government's funding requirements. As at the 30th of September 2021, this amounted to approximately 1 trillion Rand. The second stakeholder grouping on whose behalf we present this evening is the South African Insurance Association, which represents the non-life insurance industry, what was previously referred to as the short-term insurance industry. SAIA has 56 members, and they represent approximately 90% of the market in terms of premium income. In other words, the value of premiums paid throughout the non-life insurance industry, 90% of that goes through the 56 members of SAIA on whose behalf we make the presentation. Now, the first point of departure, and this has been highlighted in many of the previous presentations, and we make this point not merely to pay lip service to the imperatives of transformation, but I need to make it clear at the outset that both ASISA and SAIA support the objectives of the proposed bill. They acknowledge the need for transformation, the need for equitable representation of suitably qualified persons at all occupational levels, and there has been engagement with the Department of Labor in relation to the targets and what those might be. I need to emphasize, though, that those engagements took place at a point in time before certain details in relation to the framework had been finalized. So, for instance, subsector targets and their recognition was one of the assumptions on which those engagements happened. The proposition that targets would not be hard-coded, and I'll come to the notion of quotas and hard coding, which has come up in many of the previous presentations, but we'll attempt to provide perhaps a slightly different perspective in relation to those matters than has been provided thus far. And the third is that fines would be adjusted as a result of, among other things, the introduction of targets. And these are some of the themes which I'll return to during our presentation at different points. Concerns have been expressed in a number of the previous presentations around quotas, and we share some of the concerns already expressed. And essentially, the concern is when one takes an overall view of the suite of amendments that's proposed, including the measure of compliance, in other words, what constitutes compliance in terms of the proposals, and construes that together with the regime dealing with the consequences of non-compliance, in other words, penalties, the failure to issue a certificate in order to secure government work and so forth. When one views the suite of amendments holistically, there's a concern that the targets may in fact be approached as quotas and interpreted as quotas. And that, of course, is problematic from a number of perspectives, some of which I'll come back to in due course. There's also a concern that some of the fines, and I say this, I'll preface it with the point that, of course, there must be a disincentive against non-compliance with transformation. And there must be an incentive to transform and to comply with what the Act seeks to achieve. But the concern is where Fines are levied on a basis not envisaged when the fines were created and put in place. In other words, the fines regime, as it exists in Schedule 1 to the Employment Equity Act, was put into place before there was talk of sector targets and detail in relation to how those might operate within a sector. And they may not necessarily be crafted and suitable to a modified regime, which includes some of the amendments that form part of the bill. And there's a concern that this may present a systemic risk to a large number of companies and potentially this sector. And I'll explain why we say that that's the case with reference to some factual examples in due course. We take the view also that a one-size-fits-all approach to targets for an entire sector would be impossible and prejudicial. The committee has heard really what was a difference in view and approach between BUSA and the FIA in their presentations in relation to this topic of subsector targets. BUSA expressed some concerns regarding subsector targets being imposed, and FIA took a different approach and motivated for them to be included. We take a similar approach to FIA in relation to subsector targets because there are very real and significant nuances in different subsectors among the stakeholders on whose behalf I make the presentation, which would need to be catered for. And some of those I will come back to during the course of the presentation. So in short, on that topic, a one-size-fits-all approach is potentially problematic, and I'll demonstrate in due course why. One needs to address the diverse nature of the industry, and there are a number of subsectors within the industry with vastly differing interests, but also vastly differing circumstances. And those include the various bullet points at the foot of this slide: asset managers, life insurers, real estate brokers, banks, retirement funds, and many others. A point which we also wish to emphasize relates to regional demographics, and it's not a point which has really come to the fore yet during today's and this evening's presentations in very much detail. The reality, as committee members will know, is that demographics in different regions within South Africa are vastly different. So, for instance, the demographics in KwaZulu-Natal will be very, very different in terms of the population makeup from, for instance, the Western Cape. So where one is adopting a uniform approach and a one-size-fits-all approach to targets throughout the country and expecting a company in KZN, which has a certain demographic profile from which to employ, without having regard to that demographic profile, of course, that can lead to severe difficulties. So, for instance, that might lead to a company which simply cannot meet the targets within that region and will suffer fines and penalties and other consequences of non-compliance, being disincentivized from continuing to operate within that area, which can lead to closures in KZN, for instance, and a move to Gauteng or another province. And this, of course, has an impact on that province's economy and on the job market within that provincial economy. We also emphasize that it's important to avoid a formalistic approach which ignores the realities as they exist within the different subsectors and within the different regions. Now, I'll demonstrate shortly that it's not mathematically possible in some instances to achieve the target in each race, gender, and occupational band at a fixed future measurement point. And of course, one of the objectives of the bill must be to effect real transformation, taking into account the realities on the ground. It does no good to set aspirational targets which are completely unachievable and then punish industry players and operators within the industry for non-compliance with those targets. So what's important is, of course, to tailor and cater for the realities as they exist so that reasonable and achievable standards are set for those who are subject to those standards. So one of the significant challenges for the stakeholders on whose behalf I make this submission is the lack of qualified individuals coming through the system. Advocate Kumalo earlier made the point that certain industries are regulated such that there are entry requirements in order to obtain certain roles within those industries. And the stakeholders on whose behalf I make the presentation are in exactly such a position. So for instance, chartered accountants and actuaries, in order to operate within the industry, would need to go through specific training and qualifications in order to be able to enter the industry. And roughly 460 Black chartered accountants and actuaries. And when I use the term Black, I use it in the term used in the legislation to include designated groups who are termed with that term in the statutes and their provisions. 460 qualify each year. And the reality of the industry is that the number of chartered accountants and actuaries who are required across the financial services sector is 4,300, nearly 10 times as many as those who qualify and then are able to enter the industry. And to exacerbate the difficulty, it's not only the financial services sector who compete for these persons. All other sectors in which those 460 graduates can be employed are competing for those persons. So these are some of the practical realities and challenges that one needs to take into account in crafting an appropriate regime which takes into account proper and reasonable compliance levels or thresholds and proper and appropriate compliance consequences, both of which I'll come to in due course. The fines in Schedule 1 to the Employment Equity Act were negotiated at MEDLAC at a point in time where targets were not hard-coded, but were aspirational. Reference has been made in a number of the previous presentations to Section 15.3 of the Employment Equity Act, which currently sits in the statute books, which makes it clear that targets are, or goals are aspirational and not hard-coded. The fines in Schedule 1 include, in the second column, the committee will know, 2% of turnover. And I'll come in a short while to what this means in this industry. In most instances, turnover is not these stakeholders' money. They play a fiduciary role. ASISA and SAIA's members' turnover consists often of clients' money and capital adequacy reserves. I've already highlighted who their members are and what they do. So, for instance, it would include invested funds by clients, which is held on their behalf through this fiduciary role, and also funds which are kept for purposes of necessary capital adequacy reserves. It's very different from a business model in another industry where, for instance, the turnover is in fact revenue directly generated through stock in trade by that company. The other reality is that net margins of these entities are often very low. One talks as low as 2 or 3%. So when one is calculating a fine for non-compliance at 2% of turnover, and where the net margin is as low as 2 or 3%, a fine of 2% on turnover could effectively close the business down. And where that happens on a widespread basis because of inadequately crafted compliance levels, in other words, targets, which are hard-coded and strictly enforced, that can really create a huge disruptive effect on the sector. And because of the extent of the sector and the reliance of the South African public and the government on the sector, it can have massive knock-on effects for the economy and the South African public at large. So it's not an understatement to say that where the fines regime were to be imposed on the current set of amendments as it exists, this could lead to massive unintended consequences and counterproductive consequences, including businesses ultimately shutting down and job losses, which is completely inimical to the objective of creating employment and creating transformation within that employment. Reference has also been made in some of the previous presentations to the Financial Sector Regulation Act. And in the last bullet point on this slide, we highlight the two sections previously referred to and make some additional points. Section 28 provides that an organ of state, which would include the Minister of Labour, must, in performing his functions, have regard to the implications of his activities on financial stability. What this means in practical terms is where the Employment Equity Act designates the minister to identify economic sectors, for instance, and to set sectoral targets within those sectors. The minister would be obliged, because he's also bound by another piece of legislation, the Financial Sector Regulation Act, as an organ of state, to have regard to the implication of his decisions on those matters when it comes to financial stability. And I've highlighted already the point relating to the issue of turnover and fines, and how ultimately that can be hugely problematic and jeopardize the survival of some of these entities and the sector as a whole. So, of course, when one talks of financial stability in the context of Section 28, it would include those sorts of risks and events. Section 78 of the Financial Sector Regulation Act provides that the minister, in performing his regulatory or supervisory function in relation to employment and labor, and I'm paraphrasing from the section itself, the committee will see that the section deals with broadly organs of state, which would include the Minister of Labor in this particular context. It provides that that functionary must, to the extent practicable, consult with the financial sector regulators and the Reserve Bank in relation to the performance of these functions. So there's a very important consultation obligation within this other piece of legislation, which we submit should be taken into account in crafting the amendments, and we'll make our proposals on how that should be done in due course, but must be taken into account, because if it's not, and the Minister of Labour performs functions under the amended Employment Equity Act without necessary compliance with this other piece of legislation, there are a number of risks that flow from that. One is, of course, the risk of challenge in relation to any decisions that the Minister of Labour takes, and that's a significant risk. And of course, it's important to ensure that where two pieces of legislation deal with the same or similar subject matter, that those pieces of legislation are aligned and are streamlined to be able to regulate it in an effective way, which is not contradictory and doesn't result in breaches of one or the other piece of legislation. The last 2 points which I'll make before moving to our proposed amendments are related to constitutionality considerations. These have come up in a number of the previous presentations, but what I'll highlight really derives from a judgment. And again, I'm speaking here as a lawyer, as an advocate. This is the second judgment that an advocate has referred the committee to. I don't do this to bore the committee, and I'll really just draw out the two key points from the judgment. South African Police Services versus Solidarity on behalf of Barnard, which the committee will no doubt have come across as being one of the very important judgments of the Constitutional Court dealing with employment equity and this act. The first point made by the Constitutional Court relates to the necessity to ensure that when one effects transformation in terms of the Employment Equity Act, one does so ensuring that suitably qualified people are advanced and one doesn't sacrifice efficiency and competence at the altar of remedial employment, as the Constitutional Court put it. And why this is particularly important for the stakeholders whom I represent is I've made the point earlier about the 460 actuaries and accountants who come through the system. So there is an acute lack of suitably qualified people in this particular industry. And that's also why subsector targets and a differentiation between sectors and subsectors, which takes into account these sorts of realities, is so important in our submission, because one must recognize these realities and recognize that it's not simply a numbers game. As much as an employer may want and need to get representativity numbers improved, that must be done in a structured way and one which ensures that suitably qualified people are advanced. The second point that is derived from this judgment is in relation to preferential treatment, which includes numerical goals and excludes quotas. And I made the point earlier that this is already built into the Employment Equity Act in section 15.3. But the danger with these amendments, if certain portions are not clarified or refined, is that the amendments may be understood and applied in such a way as to impose quotas, which the Constitutional Court has said must be guarded against. I move then to our package of proposals aimed at addressing the risks that we've identified. We start off with section 15, capital A, dealing with the sectoral targets. And we've proposed in section 15A2 that the wording be refined to include the phrase "in consultation with," and Advocate Kumalo has already addressed some of the reasons for that. We align our position with that. He's referred to a judgment of the Supreme Court of Appeal, which will be provided to the committee dealing with that. So we don't need to cover that ground again. And we've proposed the addition of the words "including regulators where applicable." And why we do so is I made the point that section 28 and 78 of the FSRA mandate this. They mandate engagement, including with the Reserve Bank and with the regulators, when an organ of state, which would include the Minister of Labour, performs certain functions and takes certain decisions. And where this is excluded from this section and the Minister of Labour does not include regulators in that engagement, then there is that potential that I identified earlier of complying on the face of it with one act, but breaching another act. And this guards against that eventuality. Section 15A3, we've proposed an insertion which allows for a sector or its regulators to provide sufficient reasons for distinction, such as a difference in skills requirements, which should inform the minister setting different numerical targets per subsector or region. This is also in line with the requirements to streamline this act with the FSRA, where the FSRA in section 28 deals with potential adverse consequences, economic consequences of certain events. And it's of course important for this consultation to take place and this to be taken into account in order to avoid those consequences. So to make this more real perhaps, and go back to the example with the 460 actuaries and accountants, the industry and its regulators would know that where a target is imposed, which is simply unattainable and has significant consequences in terms of penalties, fines, the inability to secure government contracts and so forth, that the imposition of those targets per subsector and region can create these risks. And this would enable communication and engagement, consultation between the minister and those functionaries and regulators to guard against that happening. We've also proposed the extension of the 30-day consultation period in section 15A4 to a 90-day period. In addition to the considerations previously highlighted in FIA's presentation, we also highlight the fact that where the minister is taking a decision of this nature, that may constitute administrative action, which of course the Constitution requires to be lawful, reasonable, and procedurally fair. And the procedural fairness requirement is the focus here, because procedurally fair decisions often require adequate and proper consultation. And where a 30-day period is set, and that's inadequate for consultation, the risk that arises is, of course, one of disputes and litigation, which one would want to avoid, because that's counterproductive and not in line with the objectives. So where there's an extension of the period, it really allows for adequate consultation and minimizes scope for disputes around procedural fairness on those decisions. The next proposed amendment is to section 22A, and that is really to delete the word sectoral targets, because we've motivated for subsectoral targets to also be set, and this deletion, if our proposal is accepted, it allows the section to encompass both sectoral and subsectoral targets. Then in relation to section 42.1, we also make the proposal that the words be added that taking of reasonable steps to achieve the applicable targets should be provided for, because one is dealing at this level with the question of compliance, and the measurement of compliance must be in line with what the Constitutional Court has mandated in Barnard, which is that we're not dealing with quotas, we're dealing with goals, which one must aspire to and attempt to achieve as far as reasonably possible, and one mustn't do so at the expense of appointing qualified individuals. So compliance in our submission should be properly measured by assessing whether reasonable steps have been taken to achieve the applicable targets. And perhaps I can pause at this point to address a question which has come up from a number of committee members at different points this afternoon and this evening, and that is, well, how does one measure reasonable steps? What is the assessment and measurement of compliance? Now, the point we're at this stage is one of legislating for a framework which can, in practice, be applied in due course. When one legislates ordinarily, what one attempts to avoid doing is taking into account every eventuality one can think of and listing them, because one will never be able to think of every factual eventuality that may come up. So where one puts in a phrase, taken reasonable steps to achieve the applicable target, what one effectively does is one creates scope for flexibility in relation to different factual circumstances that will arise in the future for different employers. One also sets a standard there, reasonable steps. One has set a standard that the steps that are taken must be reasonable. That standard will have to be assessed with reference to a value judgment that's taken at a future point in time in relation to a specific factual circumstance, but it's still a value judgment which will have to take place within a legal framework. And the courts have dealt at length with what reasonable steps entail in various different contexts. So there is already a pre-existing legal framework for how one applies one's mind to reasonable steps. And what one needs to guard against is attempting to over-legislate by catering for every eventuality and then inevitably not being able to list every eventuality because one doesn't know what those will be. Every set of facts will be different. An example in one of the previous presentations was that we have 10 vacancies and we actually need more people than that to meet the actual targets. That is the circumstance of that particular employer, and every employer will have a different circumstance. One employer might happen to be in a province or in an area within that province with very limited numbers of certain people from certain groups. And then the question that will have to be asked as to whether they've taken reasonable steps is on that set of facts, have reasonable steps been taken or not? So this also avoids a one-size-fits-all model and preempting every set of facts that might eventuate in every circumstance, which one generally seeks to guard against when formulating legislation. We move next to section 53 of the the amendments to Section 53 dealing with the issuing of a certificate of compliance. And our proposal there, similar to the previous proposal, is that provision be made for reasonable steps to comply with those targets to be the secondary measurement level. You'd look firstly at whether the targets were achieved, and secondly, whether reasonable steps were taken to comply with those targets. And importantly, questions were asked in an earlier session around the provisions of subsection 6B of Section 53. I think you asked the question in a previous session regarding the whether or not the defense in that section solves the problem. And I think the state law advisor had also raised a question around that issue at an earlier point in time. The first point that I'll perhaps make on that issue is because the paradigm is that we're dealing with goals and not hard-coded targets. And the Constitutional Court has said hard-coded targets and quotas are inappropriate. The assessment of compliance must take place in that paradigm. In other words, whether or not you've complied must be assessed by recognizing that you don't have quotas. We test your compliance in relation to whether or not you've done whatever's reasonably possible to comply. It would be contrary to the constitutional principle that one must avoid quotas to say you may have a situation of non-compliance where you need to raise a defense that there are reasonable grounds for your non-compliance. Because when one deals with it as a defense rather than as a measure or assessment of compliance, one is potentially going down the road of dealing with the matter as an issue of quotas, rather than recognizing that quotas are not appropriate in this regime, as the Constitutional Court has said. With reference to the fines and penalties regime, the provisions on fines and penalties are not part of the suite of current amendments themselves. In other words, the sections within the bill don't include the Schedule 1 fines regime in the table, but the difficulty potentially is when one reads the schedule, which includes non-compliance with Section 20 of the Act, which is part of the amendments, there's the potential that where non-compliance is in place because of the targets either being inappropriately set or the definition of non-compliance being overly harsh and not providing for reasonable compliance, that one may end up facing significant fines. And this ties back to the point, Chair, honorable members, that I made earlier, that where the net margin of these entities, because of how turnover is calculated, is relatively small, and a fine of 2% is levied on that, that can have huge and disastrous consequences for their continued survival. So when it comes to fines, ultimately, our suggestion and submission is that this is a matter that should be considered for inclusion as a topic for further consultation in due course, prior to the publication of notices in terms of Section 15A. But we make the point, and we really flag the concern at this point in time, that if one simply ignores the interplay between these amendments and the fines regime, and the necessity to have an appropriate fines regime, especially in sectors where margins are very narrow and where turnover is calculated in a certain way, one can have unintended consequences where the regime becomes overly punitive to the operators within that industry. And in a large industry like this, the upshot of all of that is that it can ultimately affect the South African economy, where government relies on them for 1 trillion rand of funding, and where the South African public, including, for instance, people who contribute to retirement and pension funds and hope one day to see the fruits of their contributions when they retire, may have that jeopardized by the fact that the providers of those funds may have their survival jeopardized by this regime. Thank you, Chair. That concludes our presentation.
Thank you so much. Did you say you also have one on COIDA?
No, Chair. Our presentation is only on the employment
equity. Okay. No, thank you so much. Can I, with regard to the next presenters, I want to stick to the program. The program says you are only allocated 20 minutes for the presentations. So we still have 7 other presenters. If we were to take the time that has been taken by Advocate Rias, we would finish at 12 midnight. In terms of our program, supposed to finish at least at 22 and 9. But already we are about 5 presentations behind. Can we ask then the next one just to present within 20 minutes? Which one is it, Ms. Madia?
Actually, the next presenters are the Master Builders South Africa, represented by Mr. Mnisi and Mr. Mwase.
Okay, Mr. Mnisi and Mr. Mwase, can you please take 20 minutes? Or even less?
Okay, thank you very much, Chairperson, and good evening to you and to all honorable members of the Select Committee. Chair, as has been indicated, my name is Roy Mnisi. I am the Executive Director of Master Builders South Africa. I am not a lone ranger. I am accompanied by our senior manager responsible for membership services, Mr. Terence Mwase. Chair, we have heeded your call to streamline the presentation, so we are not going to tell you all sorts of things. We'll cut to the chase, tell you who we are, tell you the areas that we believe you should take into account as lawmakers when you proceed with the process of making this law, which we fully support as Master Builders South Africa. Chair, I do not see the slide flighted there. I'm not sure as to whether the expectation is that I do it myself, which I don't mind, I can do it. But it looks like the host has disabled me from sharing the screen.
Enrico should have the slides, Chair. If you can just proceed.
Enrico, can you run the slide?
Chair, but I'm just having problems here by getting this one.
Or can you share the rights then to Mr. Mnisi so that he can run the presentation himself?
Okay, because the rights has been assigned, Chair.
Okay. You can take us through then, Mr. Mnisi. The rights have been set with you as a co-host.
Okay, Chair, I have shared it. I'm not sure if you are able to see it on your side.
Not yet.
Not yet. Let me try again.
Yeah, we can see it now. If you can have it as a slideshow, please. I'll remind you when you are left with 5 minutes. I think your 20 minutes starts now.
Thank you very much, Chair. I've already done the greetings, so I will not go back there. Chair, as I've indicated, our presentation is one of the quickest. I should be able to do justice to it within the allocated time. We are going to introduce Master Builder South Africa to you. We will give the summary of that, and we will zoom in directly, Chair, to certain sections that we believe you need to be looking at.
as you concluding this piece of legislation, and we are going to conclude, Chair, with recommendations that we believe should be taken into account. So, Chair, as I've indicated, we are introducing ourselves, Master Builders South Africa. It's a federation of registered employer association. We are representing contractors and employers in the construction industry. Chair, we have got 8 Master Builders Association and 2 affiliate associations, and represent more than 4,000 contractors and employers in the construction industry. Chair, this is one of the very old organizations that was formed in 1904, representing the interest and promoting the interest of members as well as the industry itself. So in a nutshell, that is our responsibility. Chair, we want to say as well, and following in the footsteps of our colleagues that presented before us, that MBSA as well and its members are in agreement that equitable representation of suitably qualified people from designated groups in the economy is central to achieving sustainable and meaningful socio-economic development. In other words, Chair, what we are saying is that as the MBSA, we are in support and will remain in support of any piece of legislation that seeks to champion the national agenda of transformation, either in the workplace or in the industry. It really doesn't matter, but we support anything that is directed at addressing the imbalances of the past. So we want to say that as well. Chairperson, however, it is our view that this current bill in its current form will have a devastating and negative effect on the building industry, and will have unintended consequences, as has been alluded to by our colleagues earlier on. And Chair, I'll elaborate on this when I get to that level. So in a nutshell, Chair, our presentation is presented to highlight the proposal to ensure that the bill contributes towards socio-economic transformation of the building industry in South Africa. My Lord, I will make reference to section 15, capital A2, which I'll not read into the record because my colleagues have already done that earlier, but that, Chair, deals with the determination by the Minister of sectoral ministerial targets. I will quickly zoom into what our concerns are around that particular section, as well as what we are proposing as Master Builders South Africa. And Chair, we understand that the section empowers the Minister of Employment and Labor to set sectoral numerical targets after consultation by notice in the Government Gazette. However, Chair, we pick up that the section is silent on the criteria to be used for identifying and setting those sectoral numerical targets. So that's one area that we are concerned about. We also, Chair, realize that the section is silent on the need for consensus between the Minister and the economic sectors in determination of numerical targets, which demonstrates adequate consultation and is crucial to setting and achievement of any targets set. So that's what we are concerned about, Chair. The level of consensus, at what point will we say there is a consensus between the Minister and a particular sector? So we believe that clarity in that regard will assist this piece of legislation as well. So, Chair, we are deeply concerned that neither the criteria for setting the targets nor the need for consensus have been included in section 15, capital A, as has been read earlier by colleagues. So, Chair, MBSA proposes that section 15, capital A2 should include a requirement for the Minister to determine the criteria for identifying and setting sectoral numerical targets jointly with the concerned economic sectors, in this case, with us as the construction sector. Chair, the other section that we want to reflect on is amendment of section 53 of the previous act by insertion of section 20 of Act 47 of 2013. Section 12 of that, Chair, 12 6B, which talks to the reasonable grounds that a company that is not able to meet this target has to show to justify its failure to comply as per the requirement of the Act. In that regard, Chair, we appreciate the fact that the section allows an employer to raise a reasonable ground to justify its failure to comply. However, we pick up that the section is silent on the definition of acceptable reasonable ground to justify a failure to comply. It is our view, Chair, that this may be subject to abuse from either side. It may be subject to abuse from the government. It may be subject to abuse from companies as well. So we propose that a clear definition of acceptable reasonable ground to justify failure to comply should be included in the Act as well. Further, Chair, MBSA proposes that a compliance period of not less than the minimum required for completion of an occupational qualification dominant for each sector, in this case for our sector, should be included in the definition of acceptable reasonable ground for failure to comply. And to that end, Chair, we're proposing a minimum of 5 years for completion of that qualification or that occupational qualification. Chair, I want to zoom into the issue of the issuing of a certificate. Chair, as Master Builder South Africa, we have found this to be very much problematic. In actual fact, we highlight the point that there's currently the BBBE certificate, which is required.
Sorry, Mr. Minister. Can you just go back to the previous slide?
I will do that, Chair.
No, I just want to make sure that the department takes note that it is failure to comply, not to qualify, so that when they respond. Yeah. Because I hear when you were talking to it, you say failure to comply, but the way it's written, it says failure to qualify. So to qualify.
Apologies, Chair, and thanks for the correction.
Yeah. Okay, so you can continue then to the next slide.
Thank you. Yeah, Chair, I was talking about the issue of the certificate, and I was indicating, Chair, that as Master Builder South Africa, we find that problematic. More so, Chair, because you already have the requirement in terms of the BBBE Act, which requires that for public sector procurement, you produce that certificate as a contractor. So, Chair, we have had some of our members that even use the word double jeopardy. So you have got to do these things over and over again. And we are of the view that this is a duplication that is unnecessary. So our proposal, Chair, is that the certificate requirement be done away with, as it creates unnecessary duplication. Moving on, Chair, to conclusion, as I've indicated. Chair, our view is that tabling of the bill at this point in time before the select committee without clearly prescribed criteria for identification and setting sectoral numerical target is premature. We believe that due consideration should be given to the need for consensus between the minister and the economic sectors in determination of numerical targets. And Chair, we are of the view that a clear definition of acceptable reasonable ground to justify failure to comply should be included in the Act. And lastly, Chair, that a compliance period for no less than the minimum required for completion of an occupational qualification dominant for each sector should be included in the definition of acceptable reasonable grounds for failure to qualify. So, Chair, that brings me to the end of our presentation. As I've indicated, I think I've done it within the time frame that was allocated to us, which was 20 minutes. Thanks very much, Chair, once again for the opportunity given to Master Builder South Africa to present their concerns around the bill. Chair, we do not, we're not going to present anything insofar as the other bill is concerned. Our presentation was only limited to the Employment Equity Amendment Bill. Thank you very much, Chair.
Thank you so much, Mr. Minister. for the presentation. You have assisted us in terms of time. We still have a lot of time in terms of the 20 minutes that was allocated. Can we use this time if members have questions? I'd like to apologize that I didn't give you the opportunity to do so with the previous presentation. But you can still ask the questions that are related to the previous one. If advocate is still here, but if not, then we'll forward the questions to Honorable Bishop.
Thank you very much, Chair. Good afternoon or good evening to everybody.
Good evening.
A clarity question on the COIDA amendment bill. How is it that hardly anyone is speaking to the amendments of this bill? Are they happy with it? If we can just get some clarity on that. Thank you, Chair.
Thank you. Thank you.
Can I also ask one question, Chair?
Okay.
Will the presenters have an issue if the concerns that they are raising are captured in the regulations to operationalize the Act? Thank you, Chair.
Okay. Mr. Mnisi, can you respond to the two questions? Why not making any submissions with regard to the COIDA amendment bill, and also the issues that you've raised in your submission? What would be your view if they are catered for in the regulations?
Yeah, thank you very much, Chair. The first question, Chair, I think it's a question that is asked to quite a number of organizations that only focused on the employment equity bill. Chair, I don't want to say that some bills are more equal than the other, but what we felt as NDSA, we thought that this is the critical one that we needed to pay attention to. There may be some of the areas that perhaps we're not happy with, or we have got some concerns, but they were not as significant as this one. So that is why we chose to only focus on this one and not the other one. Chair, with regard to the second question, inclusion of certain aspects that we have raised in the regulation. I don't think there's anything wrong with that, Chair. Perhaps the bill should have been read with the regulation, because if you're dealing with the bill and you're not dealing with the regulations at the same time, you're not quite sure what the regulations will be covering. And taking into account the importance of those areas, we reflected on areas that are already in the bill itself. So that is why we're feeling that it's just a need for those sections to be looked at in a different way than the way they are at this point in time. But I won't object to certain issues that have been raised to be covered in the regulations. Thanks, Chair.
Thank you so much. Are there any other questions, honorable members? If not, let's thank Master Builders of South Africa for the presentation and also the responses to the questions that have been asked. Thank you so much. So by now you know what the process I've indicated, that the presentation has been shared with the Department of Labor. It's definitely going to respond to the issues that you have raised. And then after that, then we will have deliberations as members of the committee. Thank you once again for responding to the advert and also making yourself available to make the presentation. Thank you so much.
Thank you, Chair.
Thank you. The next presentation.
The next stakeholder is COSATU, represented by Mr. Matthew Parks, and he is on the platform, Chair.
Okay. Over to you, Mr. Parks. Your 20 minutes starts now.
Okay, thanks. Sorry, thanks very much, Chair. Sorry, I hope I just need to be given sharing rights, if that's possible.
I hope I have not infected you.
No, I got my vaccinations last year, and they helped me when I got my little experience with COVID. But I think, yeah, if the committee secretary could just give us sharing rights, and then we can share presentation, Chair.
Okay.
Okay, thanks.
I can continue, Mr. Parks.
Sure. Yeah, no, thanks very much, Chair, and we'll try to be to the point as quick as possible. I think I should be able to get it to 15 minutes roughly. But Chair, yeah, thanks for giving us space as COSATU to raise our views. We'll be speaking to both the employment equity and the compensation of injury on duty amendment bills. For workers, both bills are critically important for different reasons. Chair, let me just speak to the employment equity bill first. And we had engaged on it at NEDLAC. We think it's a critical amendment bill that will help us to achieve the progressive targets of the Act. And I'll support it based upon several key provisions. But we do think there is a need for one important technical amendment just to address one mistake or one gap. Chair, I think first of all, we want to welcome the linkage with the National Minimum Wage Act, providing provisions in the bill for employers to report on their compliance with the Minimum Wage Act. We think is going to help provide synergy and help to ensure employers are held accountable and are in compliance with the Minimum Wage Act. So I think for us is a useful thing. We also welcome provisions requiring employers to report on matters related to collective bargaining, as well as sectoral determinations. And again, this is going to help to ensure compliance with these progressive obligations and statutory as well. Chair, on the disability front, I think we want to welcome the expansion of the definition of disabilities to include persons with intellectual or sensory disabilities. This is long overdue. On the issue of sectoral targets, we welcome the provisions empowering the minister to set out economic sectoral targets. This is critical because each sector is not the same as the other. Some sectors have made significant progress in meeting their targets, and others have fallen significantly behind. So there's a need for a balanced, flexible, agile approach. And we think we also want to welcome the provisions allowing the minister to set targets according to occupational, regional, and sub-regional needs. You would also find that different occupation strands often remain laggards, for example, low-skilled jobs or managerial positions. So again, there's a need for agility. Chair, I think we also think, as some previous speakers have said, that it's important for targets to take into account South Africa's regional and sub-regional demographic diversity. We are a diverse nation, and this is often linked to geography. So a blanket approach will not work, and a one-size-fits-all target can actually cause social strife. So the provisions requiring the minister to engage when setting targets with the Employment Equity Commission, we think will also help to ensure that the targets are thoroughly considered beforehand. We know these issues have been subject to court cases before, so it's critical to get it right. Chair, there's one proposed amendment on this regard for section 42(1)(a), where it speaks to the extent to which suitably qualified persons from and amongst the different designated groups are equitably represented within each occupational level and that employer's workforce in relation to the demographic profile. Then it says, of the national and regional economically active population. We think that we must simply replace the and between national and regional with all. You can't be in compliance with both in many instances, and there's a need to give employers some flexibility to select which demographics are relevant for their workplace. We think not correcting it will create massive legal and workplace challenges. And I think the Department of Labour had made a presentation to this effect to the committee, if I'm right. So we'd want to support their proposal. Chair, we do want to welcome the provisions requiring employers to consult with trade unions. We think this will help to strengthen collective bargaining and to help build labour market stability. We support the provisions empowering the labour inspectors to enforce compliance by the employers with the Act. And this is critical to ensure inspectors are fully empowered and also to help ensure the department is able to deal with recalcitrant employers. Chair, on the compliance certificates, really want to welcome this, that government tenders may only be issued to companies in compliance with the Act. So they must be in compliance with sectoral targets, reporting requirements, or not having been found guilty in the previous 3 years of unfair discrimination or paying below the minimum wage. And we think it is critical for the Department of Labour and Treasury to make sure this is operationalized, because often you find these provisions are there in law, but then government doesn't operationalize them. So Chair, in conclusion on the Employment Equity Bill, we want to simply say we support it as COSATU. We think it's progressive. It will help assist us in addressing the legacies of discrimination. It's fair and rational, and will empower the state to deal with belligerent employers. We think it strikes the right balance to allow for regional diversity, which is a matter requiring sensitivity. And we welcome the link for state tenders to be given to employers who are in compliance with labor laws and with good labor practices. So on the Employment Equity Bill, Chair, we urge Parliament to prioritize and to pass it as soon as possible. I would want to urge Parliament to defend its progressive provisions, not to be convinced by calls to weaken these. And, this has taken many years to reach Parliament, so we would want to see it being concluded during the course of this year. So that's our submission on the Employment Equity Bill, Chair. Just to get to the COIDA Bill. On the COIDA Bill, Chair, as COSATU, we strongly support it. We think it's a critical amendment bill. It's going to strengthen protection of workers from injury on duty. It's going to increase relief and rehabilitation for those who are injured, and in particular the 900,000 domestic workers. We support it for several of its key progressive provisions, but we do have 2 proposed amendments which we think will help to strengthen the right to rehabilitation and provide conditions for granting licenses to insurance funds. So, Chair, we had engaged on this bill at COIDA in 2018, at NETLEC, sorry. I think we must express our concern as COSATU how there was many delays in getting this bill to Cabinet, to Parliament. And there are consequences when we delay getting bills into Parliament for workers, like domestic workers in this instance. And we would recall how this even was taken to the Constitutional Court, and this could have been resolved long ago. Chair, I think in the process on the bill, we think it needs to be strengthened in 2 areas. We want to see Parliament prioritizing its passage. But of course, when it's passed into law by Parliament, we need to see government being ready to enact and to implement it. But equally, we need to see employers embracing its spirit. And we need to also, as unions, work to educate our members and our workers on the rights. And I think, Chair, the department also needs to assist the compensation fund to modernize its systems to avoid endless delays. So in terms of the areas of support in the bill, we welcome the provisions for compensation, the inclusion of all medical costs, the constant attendance care allowance, and funeral costs. Most workers, especially the industrial workers and workers at risk, don't have medical aid. Medical aids, despite the propaganda, frequently exclude significant costs from coverage. And we think this provision will actually assist many workers with unforeseen and unaffordable costs in the moment of need, or in the event of a loss of a breadwinner for a family. Chair, on the issue of dependence, we support the provisions which seek to include life partners, spouses under different marital regimes, live-in partners, children, including fully and partially dependent adult children, parents and siblings and grandparents. I think this is critical to reflect South African cultural norms. The domestic workers, Chair, we strongly support this provision. It's long overdue. It's going to benefit 900,000 domestic workers who are overwhelmingly African and colored women. They should never have been excluded. And I think, Chair, the consequence of us delaying this bill for so long has meant many domestic workers have been denied relief when they were needing it. Chair, we want to welcome the provisions for post-traumatic stress disorder. This is critical for many workers exposed to violence or other horrific workplace incidences. This will benefit in particular security guards, mine workers, police and correctional service officers, many other workers exposed to violence or traumatic incidences. It's also going to benefit women who are often subject to violence and abuse at the workplace. On the resultant disease cover, Chair, we welcome the inclusion for cover of diseases resulting from the workplace. And again, this is critical for many workers exposed to unhealthy workplaces. Examples would include exposure to asbestos in mining and construction, hazardous materials in the chemical industries where you come from in a previous lifetime, Chair, or more recently, workers exposed to COVID-19. So this, we think, is going to provide significant security and relief to millions of workers and their families. Chair, on the Compensation Fund Board, I think we support the provisions setting out the board's membership and NEDLAC's role in facilitating nominations from organised labour and business. This is an employer and employee scheme, so it should reflect that. So we support the criteria for the appointment of board members and even when warranted, their removal. Chair, we must welcome the no-fault rule. We think this is critical. It's going to avoid unfairly excluding workers. Accidents usually always involve some degree of fault. So the point of the compensation fund is to assist workers with the medical costs with rehabilitation, reintegration, and their families. We should not be using it to punish workers and the families during already very difficult conditions for them. We do welcome the 10% of earnings penalties. We think this is a fair provision. We accept there's flexibility within it, but we think it's necessary to ensure employers take compliance seriously and that those who blatantly break the law are dealt with firmly. So we think the requirements to meet compliance are fair and rational and not onerous. Often we do see some employers simply choosing to ignore the law. We welcome the extension of the time to submit claims from 1 to 3 years, and this is going to assist workers battling to recover, those unaware of their rights or lacking the means to submit claims. But of course, government, employers and unions also need to make sure that employers and employees are aware of the provisions. We think the additional 6 months provision for workers to submit objections when good cause can be shown is useful. And again, this is going to help workers to gather the required documentation or provide additional space as a need arises. Again, Chair, on the issue of labour inspectors, we welcome the provisions providing for the powers of labour inspectors and the duties, especially compliance orders. But we think these are quite critical to ensuring the effective implementation of the Act, protecting the rights of workers to work in a safe environment, that inspectors have meaningful powers, and that belligerent employers can be held accountable. Chair, we had a lot of discussion on the issue of road accidents, but we do welcome the balance here that there's cover for road accidents occurring during the course of work under the compensation fund, and that to avoid double dipping, accidents that occurred outside of the course of work would fall under the road accident fund. We accept the conditions, we accept the need for the role of lawyers in often complicated submissions and given the backlog of applications. But we do feel the lawyers' fees are often excessive, and this is at the expense of claimants. We think they're often robbed of the little money is due to them, and that this also strains the compensation funds, resources which are very limited and are funded by taxpayers. So we welcome the provisions placed upon lawyers in the bill, and in particular that the courts have a role in setting fee limitations. But again, we need to ensure this is enforced. On the responsibility of employers and contractors, subcontractors, we support the provisions provided in the bill, providing for responsibilities for all three categories of employers. And again, this is critical to ensuring workers' rights are not undermined by outsourcing, and that all the employers, under whatever guise, are held accountable for their responsibilities. Chair, we think it's very useful that in this bill, because people often demonize labor laws, that there are provisions here which provide incentives for employers who are in compliance with the Act, who embrace good labor practices, a safe work environment, embracing rehabilitation of injured workers, ensuring injured workers can go back to work. So we think the incentives here are quite progressive. And again, employers must embrace their roles in promoting labor market stability and decent work effort to boost productivity and to spur economic growth. So Chair, just in terms of I'm getting towards the end, our two proposed amendments to the bill on guaranteeing workers the right to rehabilitation and setting conditions for the issuing of licenses to carry on the business of insurance, we've got two proposed amendments. The first one on the right to rehabilitation, Section 70A. The bill seeks to meet correctly South Africa's legal and constitutional obligations to ensure the rights of workers to rehabilitation and to return to work, as outlined by the ILO, the UN, the Constitution, and the Disability Strategy. We think, Chair, that the wording needs to be fixed in one regard under Section 70A, because we fear that otherwise, if it might undermine the purpose of the amendments, which is to provide for the right to rehabilitation. So as presently drafted, Section 78 gives the compensation fund and its licensees a discretion to provide rehabilitation rather than simply an obligation on them to do so. Section 78(1)(c) restricts the concept of rehabilitation to an employee returning to their previous employment, and that's the key kind of point. So we think that can only might inadvertently restrict the rehabilitation aspect to simply saying you want to rehabilitate a worker to go back to the previous job. We think it needs to be dealt with to enable an employed person to be rehabilitated so as to perform work either as an employee in the previous job or any other job, or as an independent contractor or a self-employed person. So not just simply to go back to your previous job, but to give you the full career opportunities that you would have had before your injury. So Chair, on this one is one single wording amendment under 70A1 to say, subject to the provisions of this Act, the compensation fund, employer individually liable or licensee as the case may be, must provide facilities, services, and benefits aimed at rehabilitating employees suffering from occupational injuries or diseases to return to work. Just before work, we just simply saying to delete the word there, so to return to work. So a more inclusive approach as opposed to the previous job only. Chair, on the second proposed amendment, the bill amends Section 30 of the Act to allow for the issuing of licenses to carry on the business of insurance of employers against the liabilities under the Act. We think this is a significant departure from the transitional arrangements in terms of the compensation fund, together with the two mutual associations that had been established when the original 1941 Workmen's Compensation Act was put into effect. So our concerns is that workmen's compensation is a unique form of insurance and that employees are prevented from bringing civil claims against the employers. We think the prospect will now rise that a wide range of organizations, including insurance companies, will apply for licenses to insure employers in particular sector of the economy. The experience of many workers is that insurance companies routinely reject claims wherever possible, often on mere technicalities, and such an approach is incompatible with the administration of workers' compensation, which is a remedial scheme. Section 37 states that licensees shall be accountable to minister, but doesn't say how the operation of a license will be supervised to ensure workers receive compensation and claims are not inappropriately rejected. So we believe that the licenses should only be issued to organizations subject to control of a board, consisting of an equal number of representatives of employers and registered trade unions. This is very similar to the composition of pension fund boards. The bill needs to include provisions to ensure awarding of claims is monitored, that the rights of employees under the Act are not undermined, that there are transparent and fair procedures for objections and appeals against decisions of licensees. So proposals, Chair, is simply to insert under Section 7, that after any licensee issue the license in terms of the Act shall be accountable to the minister, then to insert a clause, be under the control of a board consisting of half of members representing organized labor and half members representing business. We also propose, Chair, that an additional clause be complied with any conditions determined by the minister or as may be prescribed, conduct the business transparently and in a manner that gives full effect to the rights of employees and their dependents under this Act. And just getting to the conclusion, Chair. In summary, COSATU supports the COIDA bill. It's progressive. It will assist us in seeking to address many gaps in the Act. This is going to benefit millions of workers and their dependents. It's going to provide cover to 900,000 domestic workers. So Parliament, again, should defend this bill. We should not be convinced by calls to weaken it or dilute it. It is a progressive bill. We trust the committee will consider our two proposed amendments, which I think are fairly straightforward, but can help enhance the bill and are quite critical. And I think lastly, Chair, that this bill has taken many years to get to Parliament, so we really want to urge Parliament, when we're confident they would agree, to prioritize, to strengthen, and to pass this progressive bill as soon as possible. So allow me to stop there, Chair, and I hope I didn't take too much of the time, and I hope I didn't speed too fast in my efforts to be on time. Thank you very much, Comrade Chair, Honourable Chair. I think you're on mute, Comrade Chair.
Oh, thank you for that. Thank you. Thank you for that. I was saying that you still had the 50 seconds. Are there any questions? I don't know if Honorable Boshoff, I see your hand is up. I don't know if it's for the previous question. Oh.
Sorry, that's from last time, Chair.
Oh, all right. Thank you so much. Any questions to COSATU on the two bills? Honorable members? It looks like everything was clear. Thank you so much, Mr. Parks, for the presentation on the two bills. As we indicated that the process is that we will allow the Department of Labor to respond to all to the input that we've made and on both bills. The date would be the 8th of March when we expect the department to come to us to present. And then on the 15th of March, we will then have deliberation as a committee. So that is going to be the process. Thank you so much for coming and also responding to the advert, and make yourself available for the oral presentation of your submission. Thank you very much. Can we get to the next stakeholder?
Chair, next we have the Injured Workers Action Group, represented by Mr. Tim Hughes.
Okay. Over to you, Mr.
Enrico, it's the wrong one. It's the Injured Workers.
Enrico, this one is Construction Alliance. Injured Workers. Injured Workers Action Group. Can we give was it Enrico? Are you fine now with the?
I've given Mr. Hughes co-hosting rights if you'd like to present. If not, okay. Let's just indicate to us as to whether or not you would prefer that we project on his behalf. There we go.
No, I think he's already flighting the presentation. Over to you, Mr. Hughes. 20 minutes starts now.
Honourable Chair, thank you very, very much indeed for the opportunity to address you. Could I also thank your Secretariat, who have been exemplary in including us in these presentations. So thank you. I am conscious and respectful of the time constraints you have set. And I'm also conscious of the question Honourable Boshoff raised earlier about questions relating to amendments to the COIDA bill, which is the bill we would like to speak to today. So the Compensation for Occupational Injuries and Diseases Amendment Bill. That's what we'll be addressing today. We'll stick within the 20 minutes of time. Thank you again.
Thank you so much.
Thank you, sir. Just IWAG, we were formed as an umbrella body to represent workers. We try and work very closely with domestic workers that have been raised by Comrades Parks a bit earlier. So we work with BUSA. We work with medical service providers, South African Medical Association. We work with HASA. We work with individual bodies and representative bodies. And we also work with employer bodies. So, for example, NIASA. So it's an umbrella body. It's a loose affiliation, a loose alliance. And our objective really is to work constructively together to try and improve the relationship with the compensation fund. So that's our purpose, and that's why we exist. We only have 2 points to make this evening, Honourable Chair, which will be a relief to you, I'm sure, and to other honourable members. One is very fundamental, and the other one is more detailed. The fundamental question and the fundamental problem we have is with the process of the drafting of the bill itself, and more particularly the very flawed socio-economic impact assessment. Now, I know that honourable members are completely familiar with the SEERs, and you've probably had a look at the SEER that was appended to the COIDA bill. Now, our contention is that this SEER is completely and utterly inadequate. Remembering that SEERs are required, we've been required by Cabinet since 2007, and every bill, every piece of regulation, or even policy has to be accompanied by a SEER. Our contention is that if you look or examine the SEER that accompanied the COIDA, it is completely and utterly inadequate for a number of reasons. It is way out of date. It was conducted in 2015, so it's 6 or 7 years out of date with a different minister, a different presidency. It actually dealt with a different system as well. So the compensation fund was operating a very different system, the Omoshoku system rather than the CompEasy system right now. Remarkably, Honourable Chair, it was drafted just within 2 months only. And here is the major point of contention, Honourable Chair.
Mr. Hughes?
Yes.
This committee is live on channel, was it 408? If you can please put your video on, if you can.
At the moment, because I'm sharing, Honourable, unfortunately, I've only got the screen.
Oh.
So I can only, I can only share the screen, unfortunately.
Oh, you can't switch on your video?
No, I can only work on the screen, regrettably.
Oh, okay. All right.
Okay. So Honourable Chair, to get to the point, the SEER is completely and utterly inadequate and in fact failed to meet the requirements of a SEER. And if you examine the SEER, you will see how inadequate it is. Let me just make one point from the SEER document, if I may. And here's an interesting point that I think that the committee perhaps should consider. The SEER itself notes that stakeholders generally know more about their conditions and the likely impact of a proposal than government officials. If drafters simply ignore their inputs, they often come up with erroneous estimates of the cost of the new measure. The time spent in consultation should be viewed as participatory research. And it goes on. This was never done in this particular SEER. So no doctor was ever interviewed, an employer body was not interviewed, and certainly domestic workers were not interviewed. And I'd like to add as well that third-party administrators were never interviewed during the course of the SEER. So it's fundamentally flawed. Now, to get to the specific, and that in itself, I would submit, or we would submit, Honourable Chair, is sufficient reason for the honourable members of the committee to give pause to this piece of legislation, to question the SEER, and perhaps consider sending back this legislation to the National Assembly. The very specific issue we wanted to address with the committee and the particular amendment, to give it context, in the original bill that was published, Honourable Chair, Section 43.4 of that bill sought to prohibit medical service providers from ceding their claims. So what happens with the compensation fund, Honourable Chair, is that due to the dysfunctionality and the failures and the chronic failures of the compensation fund, all of which have been pointed out last week, for example, by SCOPA. And if you'd like to consult the SCOPA committee notes, particularly relating to the Auditor General, those failings are detailed there. And the Section 43.4 attempted to remove the facility whereby third-party administrators would assist medical service providers in administering their claims against the fund. And some of these administrators too will pay in advance. So they will say to a medical service provider, look, you've treated an injured worker, but you may have to wait 2 years or longer to be paid. We will take care of that claim. We'll do the administration, we'll submit the claim, and in fact, we will pay you in advance. Now, obviously, there's a discount there. So it's a relationship and a service that actually works very, very well. It's been working well now for 20 years. There are no fraudulent claims as far as we know. There's never been a claim against any of these pre-funded third parties. It works well for medical service providers. And the bonus here, Honourable Chair, is that workers know they're going to be treated. So workers have every guarantee that a private medical service provider will treat them. Why? Because they're going to get paid under this system. Now, extraordinarily, the bill attempted to remove that facility, and for no stated reason. We are still trying to get reasons why this section was inserted into the bill, yet the National Assembly Committee removed that section of the bill and did a fantastic job in doing so. But here's the problem. The section 43.4 of the bill, in other words, the removal of this clause that tried to stop medical service providers from using administrators and being pre-funded to get paid, was replaced by the following clauses. So it's an amendment of 73, and it is still section 43 of the COIDA bill. Honourable Chair, the 43.4 was replaced after the fact. When I say after the fact, this was at the end of public interventions and public submissions. So this was inserted right at the end, that no third party will be allowed to transact with the compensation fund unless they're registered with the compensation fund in the manner as prescribed. Well, here's the question. The manner has not yet been prescribed, so it's completely and utterly open. In other words, what was in section 43.4, the removal of this facility, could still be within the regulations that are going to be drafted. All third parties that are already transacting with the compensation fund must register with the compensation fund within 6 months after the commencement of the compensation fund for occupational compensation for occupational injuries and diseases amendment act. And 5, for the purpose of this section, a third party means any entity that transacts with the fund with the aim of assisting either the employee, employer, medical service provider, or pensioner with the processing of claims. So you will see, Honourable Chair, that in effect what has happened, although 43.4 has been removed, power has been given over to the Minister, to the Director General, or the Commissioner of the Compensation Fund to write regulations as he sees fit that may in fact achieve exactly the same objective, but through executive power, through regulation, without any oversight from Parliament, without any input from stakeholders, particularly, Honourable Chair, the vast range of stakeholders who would be affected by these regulations. So we have now removed the possibility of having any input into these regulations as well. And I would just raise a couple of points in relation to that. It could cut out any third party from dealing with the compensation fund in a very capricious way, in a very arbitrary way. We don't know, but this is now within the bill as it stands now. The rationale for the registration hasn't been made. It's not at all clear. It hasn't been stated. The criteria for registration are not clear. The manner that is going to be prescribed has not been developed, and yet we've allowed it to be embedded in this bill. And the compensation fund at no time provided an explanation of the reasons or the justification for the registration to transact with it. This has been going on for 20 years successfully. So we don't know why we would have to have this registration. And the real danger for us in terms of the abuse of power, and something I would submit, I would ask the honourable members of the committee to consider very resolutely, is that this clause arrogates or leaves or cedes to the Minister, to the Director General, and indeed the Commissioner, huge unfettered power to effectively remove parliamentary oversight, because it's so open-ended. The bill allows the Minister, the DG, effectively to draft regulations with no oversight whatsoever. And for us, this is a huge danger. So what we would like the committee to consider, please, Honourable, is to not only look at the socio-economic impact assessment and its profound weaknesses and its failure to pass muster. We would ask you, please, to look at the amendment to 73, which is now clause 43. Look at the insertion of these, or the proposed powers arrogating to the Minister to regulate transactions with the fund. And I would submit to you, these may well be ultra vires, but I would say to you politically that they are dangerous. They are far too wide-ranging. They are open-ended. And they really remove, as it were, the power of Parliament to exercise oversight. So we have this deliberative process, we're involved in a legislative process, but in fact, this clause would remove the power of Parliament to exercise oversight. And that is not an idle threat. In October the 19th this year, the Compensation Fund arbitrarily issued a notice to effect ensure that only medical service providers, for example, would be paid by the compensation fund. And it's already begun to try and give effect to perhaps what these regulations are trying to do. And in effect, trying to directly reinsert clause 43.4 back, not through legislation, but through regulation. And I would ask respectfully and humbly for the committee to consider those dangers and to send those clauses in particular back to the National Assembly. I thank you so very, very much indeed for the opportunity to speak to you.
Thank you very much, Mr. Hughes, for the presentation on the COIDA amendment bill. At this stage, I'll allow the honorable members to ask questions for clarity, if any. Any clarities? Maybe from me, Mr. Hughes, if you can just repeat yourself, because I got confused with regard to the amendment that you said was inserted by the National Assembly.
Yes, Honourable. So,
which is Section 73.
Yes, Honourable.
Of the Principal Act.
Yes, Honourable.
It says, notwithstanding the provision of subsection to the medical practitioner may, after claim have been finalized. Is it that one?
It's 43. What is now 43? That's correct, Honourable. So you will now see it in the bill. So it's an amendment of the original clause 73, which is now 43, clause 43 in the new bill. Quite correct. And you will see the particular insertion of those registration and regulatory requirements within that particular clause. Exactly right. If that would, we would be most grateful if you could apply yourselves to that particular clause and to not only consider whether that's problematical, but the process itself. In other words, our contention is that particular clause or those provisions were inserted at the end of the public consultation process. In other words, we effectively had not had the opportunity to interrogate that amendment.
So you're not happy with this amendment from the National Assembly?
That is exactly, that's exactly the point, Honourable. Crisply put, we're very unhappy with the socioeconomic impact assessment, which we think undermines the bill itself. But the very crisp and specific point is the insertion of this regulatory provision within 43 at the moment. We feel it probably will achieve what the National Assembly removed under its deliberative process last year. So it may well achieve exactly the same things by stealth and by executive fiat as opposed to legislative input.
All right. No, I hear the point. But you say that effectively, when you say you must return it back to the National Assembly, the process would be that we should have a report as a committee. If we were to take your point, meaning that we will have to reject the bill, and that would then be the recommendation to the plenary session of the NCOP, and therefore, if it is agreed to by the NCOP plenary, it must then go back to the National Assembly, and they can pass it with or without amendment. So it doesn't really help you in that regard. So the best would have been if you had the proposals that you would ask this committee to consider. It would be better that way than to say let's reject it, because even if we reject it, there's no guarantee that the National Assembly won't pass it on its own with or without amendment. But even if there would be amendments, still the National Assembly could pass it. We would consider the amendments, but it can pass it with or without in terms of the Constitution, Section 75. But as I indicated, we will await then the Department of Labor also to clarify this matter, and then we will deliberate as to whether we agree with you or we agree with the department or any other stakeholder on this aspect. Otherwise, thank you so
may
much.
May I ask you, and thank you, your point is extremely well made and extremely well taken, and I thank you for your counsel, advice and guidance. Would it be in order if we submitted a clause, an amendment clause to the committee as a suggestion with respect to this particular amendment for consideration, or is that too late to do that now? Could we do it in writing to you?
Yeah, like we have agreed with other stakeholders that will also be submitting additional information. We'll appreciate that, but we will also share it with the Department of Labor. But take into account that we'll be meeting with the Department of Labor on the 8th of March. So if it could be done this week, it will be better, so that we forward the proposal.
Thank you so much. We greatly appreciate it. Thank you, Honourable. We will do so. Thank you, and thank you to the committee.
Thank you so much, Mr. Hugh. Thank you for your presentation and also coming to make a presentation on the COID amendment bill. The next one, Ms. Madia.
Hi, Chair.
Construction.
Okay. Yes, Chair. The next presentation is by the Construction Alliance of South Africa. The delegation is Mr. C. Campbell, Mr. R. Hull, and Ms. Harbajan. I believe Mr. Campbell's got co-hosting rights and he will be presenting.
Okay. Your 20 minutes start now, Mr. Campbell.
Thank you very much. Thank you very much, Honourable Chair. And firstly, allow me to acknowledge the other honourable members of the Select Committee. My name is Mr. Chris Campbell. I'm going to be presenting on behalf of Construction Alliance South Africa. I'm also the Chief Executive Officer of Consulting Engineers South Africa. And joining me today is Mr. Richard Hole, as well as Mrs. and I think the program erroneously and gender incorrectly says Mr. It's a Mrs. Vikashni Harbajan. So just a slight correction.
Okay.
We make sure that we are representative as possible. So moving on, Chair, I'm going to try to stick to the time limit that's available to us. And in doing so, I may not go into all of the details. So this is a list of the contents. This presentation was shared previously with your Select Committee. And I'm going to cover some of these topics in the briefest possible time. The history of the engagement, systemic constraints, the career issues, the pipeline, and I'm going to not dwell so much on the legal inconsistencies, simply because I believe that many of the other speakers might already have covered that ground, and we'd simply be repeating a lot of that. So moving on, by way of introduction, Chair, firstly, the organization, Construction Alliance South Africa, was formed. It's made up of 36, as of today, 36 of the sector's professional organizations, contractor organizations, and supplier organizations. Its roots come from a coming together of the entire value chain in the construction industry under the COVID-19 hard lockdown umbrella as a means of getting the industry back onto its feet. We today remain a collaborative grouping, rebranded to be known as Construction Alliance South Africa. And you will notably have seen that as a mature organization, there are signatories to the Construction Alliance, such as Master Builders South Africa, Black Business Council for the Built Environment, and SAFSEC, who will be probably following us, who are doing separate presentations. Now, you may ask, why am I making this qualification? I think the point we want to make is that under no circumstances can we claim that the industry is united on this issue. There are some divergent viewpoints. So consensus is not of necessity the order of the day, But our intention behind the representation today is to provide constructive input so that we can ensure a sustainable industry in support of sustainable transformation. And sustainable is key here, Chair. So, firstly, a bit of a genesis, and I'm not going to go through all of this. There has been quite a bit of engagement with the Department of Employment and Labour, a couple of meetings, a couple of presentations, a couple of letters, and it's as though we found ourselves not really being either understood or heard well enough. So we thank you for this further opportunity. And along with all of the issues, we want to now maybe focus more on not so much the legislation, but the systemic constraints that industry faces. So in doing so, firstly, it's a legislative requirement, for example, for a registered professional in a senior and top management position in a construction company or consulting engineering company to perform their duties. So the key word is registered professionals. And what we have to acknowledge is that in many of the industries, and even, for example, in the consulting engineering environment, it's largely knowledge-based driven at the top. And so the majority of the management team are directly involved in the operational activities of the business and are so held liable for compliance in respect of the acts, which I shall cover, essentially the Occupational Health and Safety Act, to name but one. So the registration requirements are indeed a career path to management as well. Now, I'm going to cover a little bit on the statistics on the feeder channels from our statutory councils, and then also the universities and schools background as constraints. So I mentioned the Occupational Health and Safety Act, the construction regulations. Firstly, they define what is a competent person, and one can reference that in the Qualifications Framework Act of 2000. So people who are then in these positions are required to have the specific qualifications and training for planning, design, administration, and the management of construction-related processes. So we're talking here about a construction manager, a principal engineer. And these, of course, all have to be registered with the Engineering Council of South Africa, the Council for Construction and Project Management, and the South African Council for the Architectural Profession. Coupled with that is the risk and liability management requirements in all contracts with the state. So you need to have registered professionals who can take that responsibility. You can't just plug in people who don't have those levels of competencies. And bottom line is, insurance companies do not cover practitioners that are not registered practitionally, so that are not registered professionally. My apologies. So that then puts your client in public sector at risk. A quick view on the career progression timeline. Now, this is the realities that we face in somebody aspiring to become a senior top manager in a construction company or consulting company, consulting engineering, not management consulting, that is. You look at starting with your professional qualification all the way through to, let's assume you get to top management. That's a 20-year horizon. So you can't just instantaneously take somebody out of university, say, well, you graduated, so now you're going to be the top manager in my company, or you're going to fit these, because that's one of the unintended consequences that we are really concerned about. But reckless companies may do that. They themselves will pay the price because you will increase your liability profile. So The current reality from the statutory councils, Honorable Chair, is from the 2020 annual reports from the Engineering Council and the Council for Construction and Project Management. We see there that if we look at just the engineering practitioners as a start, in the category of professional engineers, out of a total of 19,523 that we have in the country, 94% are male, 6% are female, and only 18% are black. And then when we look at the technologists, you see the numbers there. And then if I look at the pipeline that feeds these eventually registered practitioners, which is candidates, you can see that the candidate professional engineers still sitting at 77% male, 23% female, and 58% black. So there's a pipeline that will possibly fill that bucket at the top end, but it's time barred. Then the same can be said about the technologists. Now, if I go to construction project managers, if you look at the numbers there, only 910 registered as construction project managers, with 98% male, 2% female, and 26% black. And when we look at the pipeline, again, we see that the demographics changing in the pipeline, but it's also time barred. Now, why have been reflecting on this is simply that just to give you a picture, a view of if we took who would be in top management today, then you would have to have assumed that a matric learner back in 2002, between 2002 and 2005, would have been eligible. But the reality, Chair, that we're faced with as a country and as an industry is our matric maths pass rate back in 2002 was 0.31%, which is a dismal number as a feeder. Now, of course, the numerical deficiencies in the numerous deficiencies in the basic education system, of course, is an elephant in the room, which we all need to acknowledge. And then the fact that out of that small pool, learners might choose a career in medicine, finance, pure sciences, or then engineering. So it does not then imply that all of those would pursue that career into engineering or project management. And if I look at where we are right now, then it seems that the problem and the situation in our education system is being, shall we say, aggravated by the fact that you have as many as 78% grade 4 learners who cannot read for meaning. And the latest information is that we are seriously going to have to find a gap to fill that left by the retirement of many of the crops of teachers over the next 10 years. And that's not even talking maths only, because certainly one would need to be looking at maths, science, and English, for example. Now, as by way of example, I just want to further illustrate the diagnostic which we got from the Department of Basic Education out of their statistics. And if you look at from 2011 through to 2019, out of a total of 500,000 learners who wrote who wrote matric, the number who wrote maths is of half of that. So we're talking 50%, 240,000. I'll go right to the end of the table and you'll see 12.6% of that number. So in other words, that's 30,000 learners out of that a 250,000 who then might have been able to get into a STEM career at university if they haven't chosen medicine or one or the other. 12.6 is a really a low number and a low base to work off. Now, What we also have to acknowledge is that the industry is not a homogeneous body. It's made up of built environment professionals, the dynamics are different, suppliers, different sizes, contractors, similarly, and again, the geographical work areas, which may not quite fit into the aspiration of setting national targets when demographics in geographical areas differ. And then furthermore, in the employment equity and the Department of Employment and Labour's scope of application, there's a confusion in and of itself, because on one side of the coin, it's having discussions with the construction sector, and it's assuming that the sector is homogeneous, but it's made up of that mixture. And on the other side of the coin, it's having those sessions with your category 13 in the Department of Employment and Labour category 13 job descriptions in respect of professional, scientific and technical activities, which is different from the construction sector. So there's a disjoint there as well. And they're assuming that what was applicable in the BBBE scorecard is a plug and play into the setting of targets for the Employment Equity Amendment Bill. Another issue that makes the setting of targets even more complex is, I quickly would like to just demonstrate that in this table that we have here, the yellow highlighted is the department's own statistics on the numbers that exist in the industry. And in green, the first line is what the numbers are that they are assuming you could simply transpose from the BBBE Act, the first dimension on the management target setting, and you could use those simply as targets. And the context is completely different. So, you know, it's important that we appreciate that. I'm not going to dwell too much on the legal contradictions other than to focus on the employment equity and its conflict with the BBBE legislation. And then, of course, we fully acknowledge that the Section 217 of the Constitution does allow for procurement to be utilized by the state for redress of past imbalances. And we support that. I think there was huge foresight by the drafters in the Constitution to realize that there would be resistance to change by some parties. But we also then believe that the target setting on an irrational and unreasonable basis that seeks to be absolutely limiting public procurement opportunities and legally may end up simply being considered unfair. I think one of the earlier presenters spoke about the quotas, but you know, we're just mindful of that. On the regulations and the implementation, the concerns we have there is an absence of consultation on the regulations. You know, how exactly are you going to go about doing things? When you have inspectors, we have this current reality, and we wish people were pure of mind and pure of heart, but who then checks the checker? And is this just not another traffic inspector sitting in a corner? I won't go into the details on that. Then I think key to this is, much as there's an appeal period, there's such a time lag in terms of most appeals. And there's a huge risk.
Mr. Campbell.
Thank you, Chair. I shall be done in a minute. And we would argue then, as an open question, is, are we really serious about sustainability of achieving transformation on such a flawed basis? And really, would we not just end up addressing this matter through the courts, around arguments through the court, which we don't believe is in the interest of the industry or our government or the country? So we want to propose a way forward, Chair. And the way forward is, since there's insufficient empirical evidence to enable this target setting, we as CASA want to commit to collaborating with the Department of Employment and Labour in conducting research, not over years, but over the next few months, to inform such reasonable and rational target setting as a short-term measure. And then as a longer-term measure, this is our proposal and our plea, is that CASA and other organizations collaborate with relevant government entities to work on constructively and sustaining and sustainably addressing the systemic pipeline issues around transformation and gender in the industry. They are real, they're the elephant in the room, they are not manufactured, and I think industry can do its, try its best, but if the feedstock is not there, it's just not there. So we got to fix that collaboratively and collectively. I want to assure everyone and the chair that certainly we remain committed to the transformation of the sector. And lastly, you know, if we don't address this long-term perspective on this matter holistically and systemically, we would like to add that sadly, we may be sitting here 20 years from now, still trying to manufacture a target for an issue which we have not paid enough attention to. I thank you for the opportunity, Chair.
Thank you so much. You're still at 41 seconds. Thank you very much for the presentation. Honorable members, any question for clarity? Seems like your presentation has been clear.
I would like to add, Chair, I'm an engineer myself, and that's why I did it within that 41 seconds.
Okay. No, thank you so much.
I want us to grow our own timber.
Yes. No, thank you so much. Though my question would be on, I was a bit worried about the 20 years that you're talking about for a person to be in top management, because the legislation talk about the suitable qualified. It doesn't say for you to be suitable qualified, you need to have a 20-year experience. So, but it's I wouldn't like you to respond to that, but it's one of the issues that perhaps when we deliberate, we have to look at it. Yeah, thank you so much.
Thank you,
I see that there are no other questions. Let me take this opportunity to thank you very much, Mr. Campbell, for the presentation. Firstly, for responding to the advert, and also availing yourself to make a presentation to this committee. Thank you very much.
Thank you, Chair.
Thank you. Can we get the next one, Ms. Matia?
Yes, Chair. The next presenters are Comsol. The leader of delegation is Mr. Latic, assisted by Advocate van der Merwe and Mr. Spruit.
Okay. Thank you very much. You are welcome. And your 20 minutes starts now.
Good evening, Honourable Chair and Honourable members of the committee. Thank you very much for affording us the opportunity to present to you tonight. As was said with the introduction, I myself is Fritz Lippich, the founder and MD of Compensation Solutions, that's dealing in the COIDA environment, and more specifically, the link between medical service providers that's treating injured workers and the compensation fund. And with me tonight is Mr. Spruit, an attorney, and also Advocate van der Merwe, who will present the second half of the presentation. Now, I'm not an engineer. I'm an agricultural qualified by nature, so I hope I'm not growing a longer beard tonight than is already necessary. Without further ado, Honourable Chair and Honourable members, as was mentioned earlier on, we are here tonight to discuss the COIDA Amendment Bill, but more specifically Clause 43.4 and 5 only. So hopefully that would not take too long tonight. What we would like to explain is just a quick overview of the process that happens when somebody gets injured at work. On the left-hand side, we have the various employers with their various employees. They get injured. There's a lot of role players that is involved in treating them, the ambulance, hospital, medical service providers, doctors of all the various disciplines. And once they are treated, there's an admin process that needs to be done to ensure that whatever the treatment is put into either medical reports or that the invoices that complies with the annual tariffs are correctly applied and then submitted to the compensation fund. Now, where we come as third-party factors is that we then administer, or rather assist, all those various role players in the administration of their COID bills or their medical accounts, for that matter. And I need to point out that that happens after the fact. Once we are happy that what they've done complies 100% with the laid down tariffs and the rules and regulations of the fund, we will then make an assessment and we will then pay those service providers on average within the 10 working days. Now, once that has happened, we have then we'll then take those accounts and we will then submit them to the compensation fund after they've been checked for compliance, who then processes those particular invoices and will then make a payment back to the third-party factor, who has then obviously already paid the necessary service providers. Just to give us a bit of background on who we are, and I'm not going to spend too much time on it, you've all seen the presentation. National footprint, we service more than 5,000 professionals. There's about 3.4 million treatments that's been administered over the past 5 years to around about 800,000 injured workers and around about 180,000 employers that were serviced. The amount of accounts, medical accounts that we've pre-funded is around about 4.5 billion over the past 5 years. And we process in terms of the number of medical accounts around 60% of all the accounts that is submitted to the fund for consideration. And we employ 438 staff in the Eastern Cape. Now, collectively, as we sit here tonight, or rather yesterday morning's number, is that the fund is currently owed to pay more than 556 million rands worth of medical accounts that's been switched to it, but that's at some stage of not being processed or paid. In total, and over and above that, there's an additional 180 million that could not even be registered due to problems with the new CompEasy system. So it's a substantial amount of services that's already been delivered by the service providers, but that is not being processed timeously by the fund. Now, if one has consideration for the amount of unpaid accounts, and you calculate the normal accounting way of calculating the time it takes for the fund to pay accounts, currently we're standing at 341 days from the date the service was delivered till the day the fund will eventually pay. And that's an average figure. I concur with Mr. Hughes earlier on that says some of these accounts take even longer than 2 years, as he said. And some of them are 4 or 5 years old and still hasn't been paid by the fund. Now, despite various engagements, instructions from the minister, there was absolutely no response from the Compensation Fund Commissioner. So it's a bit of a problem if one tries to resolve issues. There's a problem fixing the issues with the software, the CompEasy system, and the staff needs a lot of training on their new system to not invalidly reject certain accounts that's been submitted to it. And as you can imagine for yourself, it is not possible for individual service providers, doctors, practices to wait 341 days for payment, nor is it practical for them to engage in the legal action that the fund is drawing out year after year, month after month, by doing all sorts of legal ducking and diving. And the main problem that we have with clause 43.4 and 5 is obviously, that's been mentioned earlier on, the criteria that has been imported into this bill to replace the original 43.4 that stipulates no criteria. It stipulates no process, and it was inserted after Parliament. It was inserted after public comment, and it has not ever been opened up for public comment as we stand here or sit here tonight. And what we're asking is that there's hopefully a just administrative action that can be taken to review this new mechanism that was introduced and open it up for public comment, because we have insufficient information as to the current requirements. And as you will see later on, we will try and make a proposal to this honourable committee that would hopefully cater for some of the relief that we are seeking. I just want to quickly point out that the factoring process is at zero cost to the employer, the injured worker, or the compensation fund. The doctors carry the full cost. And the factoring process is post the patient treatment. It does not prohibit medical legal against the medical service providers, and it's a common legal financing agreement. Third parties like ourselves are gatekeepers, aggregators. We're not the problem, but we need legal access to the courts. And the way the fund is doing it at the moment is that they're trying their best to exclude the third-party assistance that's given to service providers and the injured workers in the whole process. So, in conclusion, we would like to draw the committee's attention to the fact that medical service providers are treating injured workers because they're getting paid. If they're not getting paid by the people, the likes of us, they will simply refuse to see any IOD cases. And it will all fall over to the government hospital facilities. I thank you for your time. That is my introduction. We will now go over to Advocate van der Merwe, who will discuss more about the legal consequences and selection at the moment. Thank you, sir.
Thank you very much, Mr. Chairperson and honourable members. My name is MP, like in Member of Parliament, van der Merwe.
You've got 11 minutes, Mr. van der Merwe.
I am a member of the Pretoria Society of Advocates, and I've been briefed by my client, Compensation Solutions, to make these submissions to you. Mr. Chairman, I align myself fully and echo the submission so eloquently advanced to you by Mr. Hughes, and I will endeavour not to repeat his submissions, but there will be some overarching and overlapping contentions which I wish to advance to you. And let me drill down straight to the offensive clauses, 43.4 and 43.5. Now, before we analyze them, let us just consider first the animal which we're dealing with. 43.5, Mr. Chairman, tells us that the third party which they have involved, which they have in mind here in this bill, is any third party that transacts with a fund with the aim of assisting either employees, an employer, a medical service provider, a pensioner, with the processing of claims. So it is wide in its sweep. It is aimed at reaching out to any third party. And then, of course, let us consider what sub 1 says, because sub 1 of 43.1 is actually the more important one. Sorry, I apologize, 43.4 A. That says no third party will be allowed to transact with a compensation fund unless they are registered in terms or registered with a compensation fund in the manner as prescribed. Now, let us just consider this. This is a very serious embargo against the right to freely trade. And the consequence of that sharp wording of 43.4A, which we've read, is that unless you are so registered, your activity, your engagement will be visited with a nullity. In other words, you would not be able to validly transact, as the provisions say, with a fund unless you are so registered. So it's an extremely serious impediment against free trade and the right to freely participate in commercial activities. Now, what you have to understand, Mr. Chairman, is of course, as Mr. Hughes had also said, there was a previous provision in a bill which outlawed the cession by medical practitioners of their invoices to an entity such as my client. That was met, Mr. Chairman, with outright public outcry, and in the end, that provision was scrapped. Now, what we now have is by the back door, by stealth with respect, this provision is now inserted in the Act with potential draconian consequences. And what it says is that you have to be registered in the manner prescribed, but we don't know what it says about the prescriptions and the procedural aspects relating to what would be required for your registration, etc. But I will come back to that in a moment. If we may just move on, what I want to also emphasize to you, and that was actually on the previous slide still, is that although 45.3 refers to third parties, which is not restricted only to medical practitioners, it is part of the chapter in the bill, chapter 8, which deals only with medical services. So with the greatest of respect, we cannot get the proper understanding of why this section is included in this part of the bill, which deals with medical practitioners or medical service providers. If in fact, if you look at what 43.5 says, it is any person and not restricted to a medical practitioner only. If we may then move over to the next slide, please. What I there want to bring to your attention is especially the second bullet. Remember, institutions like my client is already registered as a debt collector under the Debt Collections Act, number 114 of 1998. Now, what's important, Mr. Chairman, if you have registration governed by legislation, the legislation itself would usually tell you what are the requirements for you to meet before you can register. Here we have this anomaly in the Act that the requirements for registration, in other words, the thresholds which you must meet, are not contained in the Act. They are left for regulation, which, as Mr. Hughes had argued, is not open to the public scrutiny process like you have with national legislation. Let us just compare this for a moment to certain of the provisions in this other act, namely the Debt Collections Act 114 of 96. I want to take you there to section 8, which says very much like our 43 4A, which says you cannot conduct business unless so registered. Section 8 says that person's prohibited from performing certain acts. Then section 9 says application for registration as a debt collector, and it says the application shall be lodged with the council, pretty much like we have in our offensive provision here. You must make application for registration, but the most significant difference now comes. Section 10 of this act, unlike the bill, says no person shall be competent to be registered as a debt collector, A, in the case of a natural person, if one subject to so and so in the preceding 10 years he's been convicted of an offense, etc. So what you find in the act itself are the jurisdictional prerequisites set in the Act of Parliament, what you must meet in order to be eligible for registration. We don't find it in this bill here, and that is going to cause immense problems because it will leave open a process and open the door that you can regulate by means of regulations all these requirements, which are actually matters of substance and not matters of procedure, because the relevant provisions say in the manner as prescribed. So the manner of the prescription presupposes that it will be confined to a procedural issue as opposed to an issue of substance. If we may move over to the next slide, I'm going to try and speed it up.
But less than 4 minutes.
What you can rest assured of, it appears to us that there's no legitimate underlying purpose for this very intrusive provision. There's no fraud established. We lack to appreciate the public interest element here, Mr. Chairman. And whilst we're there with the public interest element, one should be careful to unnecessarily over-regulate. Let me give you two examples of immense frustration encountered in practice by this requirement of registration. Let us take estate agents. It has happened many times in my practice that an estate agent comes to me and say, listen, there's an act which says I cannot sell properties for a living and earn commission as an estate agent unless I'm registered at the Estate Agencies Affairs Board. I've written them 10 letters. I've submitted my application 6 months ago. I'm getting no response. What do we have here with the fund? We have complaints, very legitimate complaints of inaction and very long periods of delays in the finalization of processes. Is this fund going to be able to properly and swiftly register? Very much like an estate agent, there might be the condition that you've got to register annually. If you've got to register annually, how long before the due date must you resubmit your applications? Otherwise, you're going to fall by the wayside, because we will recall that the provision says you are prohibited from transacting unless you are so licensed. So that's a gross infringement on the liberty otherwise available for a person to freely contract. We read in the press every day of the lack with firearm license applications, where there are stacks and stacks of papers lying and people are waiting 2 years for a license. Of course,
1 minute. 1 minute to go.
We're alive to the issue that this is different than firearms, but still we faced with a serious risk of much delays. If I may then, with your permission, move to what we proposed to you, and I want to get to the slide where our proposed solution is contained. We recommend, Mr. Chairman, that the bill be rejected in terms of section 75(1)(a)(3) of the Constitution and referred back, or recommend to NCOP that the bill be amended in terms of 75(1)(a)(2), read with 75(1)(c), by removing clauses 43 and 43 sub 4 and 5 and refer it back. And then we have a solution which we propose to you. We shall say there's already an act, namely the act which I've referred to you earlier, where there is a requirement for debt collectors to be registered with a well thrashed out regulatory system. And we say it should be amended to read as follows: that any party claiming medical costs from the compensation fund, either on behalf of a medical practitioner or in respect of rights ceded to it, shall be registered with the Council for Debt Collectors and be regulated in accordance with the Debt Collectors Act and associated Code of Conduct. So we say it is not necessary for an over-regulation, a multiplicity of requirements of registration, but our main objection, Mr. Chairman, remains you cannot bring this kind of huge infringement in by virtue of regulation. And it's outright unconstitutional, and you ought to reject it. And those are our submissions, and thank you very much for patiently listening to me. Those are what we have to say.
Thank you so much, Stefano Murphy. As a procedure, then we will await the department as a response on the proposal that you've made and the concerns that you've raised. And thereafter, we will have a moment where we'll then deliberate on all the submissions and the responses of the Department of Labor. Thank you so much to you all for coming, COMSOL, and also making presentation. Thank you so much. I'll just want to check if there are any questions. I see Honorable Dango, you have your hand up, followed by Honorable Boshoff.
Thank you very much, Chairperson. Chairperson, from a constituency basis, maybe not related to this, maybe related to other medical claims by third parties such as this one. The description is really that there are people who want to put people on cement shoes on people without actually having any authority to do so, and that when you take them back to the hospital or to the medical aid concerned, they have no information. They are just debt collectors putting on cement shoes, and they have no interest in resolving problems. Chairperson, so I think we should in fact strengthen the regulations on debt collectors. Thank you very much.
Thank you so much, Honorable Boshoff.
Thank you very much, Chair. It's just a comment, if I heard correctly. They spoke of the compensation fund taking up to 341 days to pay a claim. If this is the case, and we're going to continue working with a dysfunctional compensation fund, we could see, and I'd like to know if this is the feeling of the presenters, that medical practitioners, to eradicate the work of extra admin, is just to close their doors to injured workers. And this is going to place a huge burden on our public health services. I just want clarity on that. Is that what they said? Thank you.
Thank you so much, Honorable Boshoff. Can we have responses, COMSOL, on the two questions?
Yes, thank you, Honorable Chair. Yeah, I agree with both of those statements, especially the fact that many service providers, doctors, physiotherapists, etc., are, as we sit here, refusing to treat injury on duty patients for the simple reason that it takes at least 340 on average, but as I mentioned earlier, a lot longer in some cases to get their accounts paid. Hence, our involvement in the market, that we pay the service providers within 10 days, and then we try and resolve the unpayment or the payment of those medical accounts directly with the compensation fund, with limited success, I might add. As you can see, the debtors book is around about 650, 700 million, and that's one company. So yes, and secondly, what we will see is that once the service providers are not getting paid, which has happened in the past, those injured workers will fall at the only other option they have, which is government hospitals. They're already overburdened. Their budgets are not catering for this particular volume of influx of injury on duty patients. And the simple reason is that they see the injury on duty patients arriving at the government hospital facilities as private patients. Private means they are not in need of government health services. They can go to a private facility, hence opening up space for the injuries to be treated at the government facilities and not those who can afford, or then by the way of the compensation fund, to be treated by private medical practitioners. I hope that answers the question.
Okay. Oh, thank you so much. I think for now we will confine ourselves to the legislation, but as this committee also oversight Department of Labor and the compensation fund, we can then convene another meeting to deal with the issues of payment as a separate issue from the legislation making process that we are dealing with right now. So I think we committing ourselves to meet with the compensation fund to deal with these administrative issues and get a briefing on these matters outside this lawmaking process. But we take into account the issues that relate to the legislation itself that have been raised, particularly by Advocate Van der Merwe. But those issues will await the department's response on them, as I indicated earlier, that and then after that, then we will deliberate on all the inputs that are coming from the stakeholders and the responses of the department on those issues. Otherwise, thank you very much for coming and making the presentation, particularly on those issues that relate to sections that you have concern with. Thank you so much. The next one, Ms. Madia.
Yes, Chair. The next presenter is South African Civil Engineering Contractors, represented by Ms. Campbell and Advocate Stelzner.
Okay, Mr. Campbell.
No relation, sir.
Oh, okay. Yeah.
Can we have a screen? Can we have a screen sharing facility, please?
I was told that the engineers keep time, so I'll give you 20 minutes.
That's all you're going to. That's all we need. Thank you so much.
Thank you so much.
So, as screen share,
Chair, can I just ask who we should give co-hosting rights to?
Screen sharing.
To Robert Stelzner.
To Robert Stelzner, please.
Oh, okay.
Done. Okay, it's been done, Chair.
All right. Continue, Ms. Campbell.
Yes. While we're waiting for that, thank you,
Oh,
Chair. And can you see the screen?
You have been given the rights.
Yeah.
To host.
Good. There it is.
But we can only see you on the screen.
You can't see the.
You can't see the presentation.
Right, while we wait for the presentation, I just want to introduce myself and thank you for the opportunity. I know it's late in the evening, but we are very grateful to have this opportunity to interact with you and your honourable members. And my name is Ingrid Campbell from SAFSEC. Can you still hear me, even though the slides are not up?
Yeah, loud and clear.
Okay, so our presentation this evening is on the Employment Equity Amendment Bill. SAFSEC has commented separately on the COID. So
we can see the presentation now.
Can you see the presentation? Okay, good.
Yes.
So, as I said, I will be outlining industry concerns and our very real concerns about the impact of legislation on industry. And with me, I have Advocate Stelzner, who assisted us in
We've lost you now, Mrs. Campbell. We've lost you now. We can't hear. Mrs. Campbell, are you still there? Or is it only me who can't hear?
She's still on the platform, Chair, but the video and the audio just went off.
Okay, let's just give a minute to reconnect. I don't know if Robert can continue with the presentation in the meantime. Okay, what I think what we must do for now, we take off the presentation and ask the next presenter to present in the meantime, and then we'll come back to is it Suffolk later. Can we get to the next one now?
Yes, Chair, the next
COIDA.
yes, if they're ready, it's COIDA.
Sorry?
Yes, you correct for the two with the names of the next presenters, Chair.
Oh, COIDA then. Okay.
Yeah.
Can we allow then COIDA to make a presentation?
Thank you, Chair. Chair, if I may request to run the presentation on my side.
Okay. Can you give Mr. Ngadiman? Oh, you've got the right, Mr. Ngadiman.
Thank you, Chair. Good evening, members of the Select Committee and the Secretariat. My name is Gideon Ngadiman. I am the Chairman of COIDA. I am joined this evening in this presentation by the Chief Executive Officer of COIDA, Mrs. Leanne Zhao, as well as the Chief Operating Officer of COIDA, Mr. Dievat Chakashli. They will be available to assist me in addressing any questions that the committee may have. Our submission this evening relates only to the compensation for occupational injuries and diseases amendment bill, the COIDA bill. And what I'm really hoping to do today is to land with the committee 3 key points. The first one is really to thank the Portfolio Committee on Employment and Labor for the transparent process with which they ran the consultative process on the COIDA bill. What we saw was democracy in action, and we are satisfied with the amendments that were finally agreed to and passed by the committee and the National Assembly. The second point is to really point out to this committee that the Compensation Fund Commissioner has used administrative powers through various gazette notices to effectively defeat the purpose of or the ends that the parliamentary process was seeking to achieve. And then the third point is to request the Select Committee to take corrective action to stop the misuse of powers by officials that really undermine democratic processes by elected representatives. So who are we as COIDA? We are a key player in the sector and a key member of the injury on duty value chain. We've been operating for the past 20 years, working with the compensation fund, working with employers, and more importantly, working with medical services providers for the benefit of workers who are injured on duty. You know, our philosophy is we put injured workers on duty, workers who are injured on duty at the center of what we do. We are a 100% Black-owned company controlled by a high-caliber board led by myself, which is also majority Black. And we have been trusted over the past 20 years by over 1,800 medical services providers to provide them with administration services and, more importantly, with working capital funding in order for them to provide services to workers who are injured on duty. These medical services providers, particularly the emerging medical services providers, would not be in a position to treat workers who are injured on duty were it not for the funding and the working capital that we provide. Like COMSOL, we have provided funding for the treatment of over 50,000 workers who are injured on duty, generating over 150,000 invoices, and over the past 5 years, those invoices amount to over 2 billion rand. And I think we want to state at the outset that we are in full support of the latest version of the bill, and have been a full participant of the consultative process up to this point, including this opportunity that we have been granted this evening. And what we understand the bill seeking to achieve is really to deliver on service delivery mandate of the government. And, you know, we welcomed the opportunity that the bill has created to, you know, to deliver on that promise, including expanding the coverage of services and benefits under the Act, to name but just a few, clarifying the role of the compensation fund and how various institutions and participants in the value chain should relate to one another. What we understood as the process of consultation was that the department proposed amendments to the COIDA bill, the COIDA Act, which intrinsically sought to ban the practice of pre-funding or the purchasing of medical claims from medical service providers in a manner that allowed us to provide funding to those medical services providers. I think other speakers have alluded to the fact that we, like them, did not understand what was this exclusion seeking to achieve. And so our presentations to the portfolio committees were presented as such. And luckily, I think the outcome was more or less, had taken into account the points that we had raised in objection to that prohibition of pre-funding to medical services providers. We were quite happy with the consultant. Sorry?
No, you can continue.
Thank you, Chair. Yeah, so as I was saying, we were quite happy with the consultative process that the Parliamentary Portfolio Committee took in reviewing this bill. And we believe where the bill ended up and was passed on the 9th of September was a true reflection of that consultative process. Our interpretation of the act, that the final bill that was that came out, was that the committee expressly declined this prohibition that the department was seeking, or that the compensation fund was seeking, and instead chose to introduce a dispensation where the compensation fund could play the role of regulating those third-party service providers. I think the previous speaker spoke to the specific clause. I won't read through it again, but to say that it does allow that third parties are allowed to transact with the compensation fund, provided they're registered as prescribed. And here we rely on the principle of administrative justice to say that those regulations will be fair to service providers, and that it says that those existing third-party providers that are already transacting with the compensation fund, such as ourselves, will be given a reasonable time to meet the compensation fund's registration requirements. These presupposes that there will be fair prescripts or regulations that the compensation fund will disclose to the industry to say what are these registration requirements. However, Chair, unfortunately, what we have seen as behavior from the compensation fund and the department, and I think the commissioner of the compensation fund is online, we have seen behavior that is almost opposed to what was the outcome of the consultative process and the final COIDA bill that is being proposed. Through two notices, one issued on the 10th of September and one issued on the 19th of October, the Commissioner sought to restrict the activities and the practices of third-party administrators, particularly those ones that offer pre-funding or working capital to medical services providers. This we see as clearly defeating the ends of the amendment by the Portfolio Committee and actually acting in bad faith towards the industry. These notices extend beyond what we believe is enabled in the Act and really seek to limit the customers of the fund, the injured workers workers who are injured on duty by preventing funding to the medical services providers. Our suggestion, and I think we need to state very clearly that we are not opposed to administrative processes such as bank account verification. We already do that in our interactions with the compensation fund. What we do object to is stopping direct payments to third parties, to the pre-funders, which effectively take away our rights in terms of the agreements that we have in place with medical services providers. I think a previous speaker, Mr. Hughes, referred to as the backdoor way of the compensation fund achieving their original needs, which were clearly rejected by the Portfolio Committee and the consultative process. From our perspective, we have, on our side, we have tried to engage both with the Commissioner and the Minister of Employment and Labour. We wrote letters to the Commissioner on the 10th of December and raised our concerns about these Gazette notices. We also informed the Portfolio Committee of these practices that are not in line with the proposed Act. And to date, we have had no response and no commitment to respond either from the Minister or from the Commissioner himself. And so we want to recommend that as you engage with the department on the 8th of March, as you indicated earlier, and as you go into your deliberation, you really take the Minister and the Commissioner to task in terms of explaining these notices that they've issued, which are, as I mentioned, were opposed, were not in line with the Act, and prevail on them to withdraw these notices, as we see them that they would render the process that the clearly democratic process of the Portfolio Committee, it would render those processes null and void. And we urge the committee to be vigilant against these abuse of powers by the commissioners that really would frustrate the legislative process that we have all participated in. In this regard, the commissioner and the compensation fund management are clearly attempting to issue to frustrate the operations of third-party administrators and pre-funders, which is something that is expressly allowed, and I think we believe that we have been properly heard by the Portfolio Committee. And so we urge the committee to really send a stern warning to the Commissioner and the management that they may not undermine the legislative powers of the National Assembly. And so in conclusion, Chair and the Select Committee, we don't make our request lightly, but we acknowledge the separation of power between the executive, the judiciary, and the legislative. However, we have attempted to engage with the commissioner, and we have written to the Portfolio Committee on Employment and Labour on the 3rd of the member to bring to their attention these attempts to undermine the legislative process. And so, whilst we agree, as is the current draft of the Act, that the commissioner does have a right to regulate those third parties, it is really to make sure that that there are checks and balances, and that those powers should not undermine the spirit of the Act and exclude legitimate transactions between medical service providers and their funders, which would be undermining what was contained in the Act and what was arrived at through a democratic process of our legislation. That those, Chair, are really our submissions. We echo some of the comments made by previous speakers around the danger of leaving too open these regulatory powers to the Compensation Fund Commission. With that, we are happy to take any questions.
Thank you very much, Mr. Ngatime. I think at this stage, before I even allow members to ask questions, I would ask Mr. Jaman, who's dealing with the COID, because when I look at the presentation by COID Link, it is more about the complaint with regard to the issue of the Gazette. Now, it's not in front of us. We don't have that Gazette. We're dealing with the bill. So our role here is to consider the bill in front of us, because we don't know anything about the Gazette. So that's why then I would first ask Mr. Mjengman and also Samara to advise the committee on these matters, but also the Office of the Chief State Law Advisor, if they can also come in before we allow members to ask questions for clarity. Mr. Mjengman. Is he here? Madia? Legal unit, is it at the year?
I see Ms. Suanne Isaacs is present, Chair. I don't see I think the State Law Advisor, I don't see him. He must have just stepped out. But Suanne Isaacs is here, Chair.
I don't know, because she's dealing with the employment equity. I don't know if she would be able to give us an advice on this one. Ms. Isaacs?
Yes, Chairperson. I am dealing with employment equity only.
Where is your colleague?
I'm not sure. Excuse me, I think the committee secretary was in contact with him, but I'm not sure whether she managed to get hold of him.
Oh, no, this is not acceptable. When we deal with the law, we expect the legal unit to be here throughout, because from time to time we'll have to consult with them, even the office of the state. Oh, Soraya.
Good evening.
Yes, yeah.
Yeah. Good evening, Chair. Chair, I'm not quite a favor with the matter of the gazettes, but what we can do is we can find out and we can get back to you, because I think the parliamentary law advisor may be best placed to respond to that.
Yes.
Yeah, thanks.
Yeah. I think I want to suggest, honorable members, that because there are no proposal from COID with regard to the legislation, as far as I understand, they are happy with the proposal that came from a portfolio committee with regard to the section 73. But what they are complaining about is the issue of the Gazette, which is a separate matter from what we are dealing with now. Though they indicate that their concern is that this Gazette undermine this process. But for us as a select committee, ours is to whether we agree with the proposal from the portfolio committee, because for now there's no amendment until it goes through all these processes. So that's why I'm saying the issue of the Gazette is a separate matter. That's why we wanted an advice from the legal unit, so that if it has to be, the issue has to be addressed, it's addressed outside this process. We either convene a meeting where COID come in to present their case, and then the department also respond, so that it's separate from this particular point, because this one is about public hearing with regard to the legislation that we either pass or we reject or we amend. So we wanted to separate those processes, but it's a pity that I don't know if Shamara is also here. Is Shamara here?
No, Chair. I think she might have just stepped out, but I don't see her yet, Chair.
Oh, okay. Okay, let me go back to the members then. Honorable Bosho, followed by Honorable Dango.
Thank you very much, Chair. I hear what you say with regard to the abuse of powers by the Compensation Commissioner, and I think it's something that must be discussed. I would then like to ask Mr. Nkadimeng whether he received any response from the committee chair or to whomever he wrote on the portfolio committee of E&L to his letter of the 3rd of November. Thank you. And if so, what was it? And if so, what was it? Thank you.
Thank you so much. Honorable Dango.
Thank you very much, Chairperson. Chairperson, I think you're quite correct that we're dealing here with something that's not before us and it's not legislation. And we're looking at issues of administrative kind of matters between the Commissioner and the company. However, the question I want to ask the company is, what is the margin between what is charged by the medical practitioner and the cost for collecting the money thereof? If they can just give us what that margin would be, it would be a good thing. If they can't give it to us tonight, at some time in the future. Thank you.
Okay. Mr. Nkadimeng.
Thank you, Chair, and thank you, honourable members. Maybe before I answer the questions, and I will invite my colleagues to help me on the technical details. Just to acknowledge, Chair, what you've mentioned in terms of the role of this committee, and to say that we will appreciate the opportunity to deal with the complaint that we have raised, and if that can be done through your processes, I think it will greatly help not only us but the broader funding industry. And I guess to go straight to Honourable Boshov's question is that we have not received a response from the chair of the portfolio committee, and my colleagues can confirm if maybe something came through or I wasn't aware of. But as far as I'm aware, there has not been any official response to when we alerted them to these issues by the compensation fund. The second question I will ask the CEO of COIDA, Mrs. Lianzao, to respond to that.
Good evening, Chair and members of the Select Committee. My name is Leanne Zhao. I'm the CEO of COIDA. I will answer the gentleman's first question, which he asked what our margins are. You do realize our competitors are sitting in this meeting, so surely that's a competitive information that I cannot give you. I can write to you and give it to you, but I cannot give it to you verbally. So that's fine.
Understandable.
Yeah. Suffice to say, and I think the point has been made before, that it is the medical services providers who pay for our services as administrators and funders, not the employer, not the worker who's injured on duty. So we do not create any friction or any additional cost to workers who are injured on duty.
Chair, may I just ask a question? I don't know whether I can.
Okay.
Excuse us, because what we are saying is the bill you've got in front of you, you are busy analyzing and looking at the bill and, hearing us all. But there's another parallel process going on with the commissioner undermining the same bill that you're considering. That's where we were coming from.
I know we understand the point that you're making. So yeah. What we're saying is that we want to separate the two, because we're not going to consider the Gazette.
Of course not.
We're going to consider the bill. Mm-hmm. That is our rule. But we're not saying that we're dismissing what you're saying. But we're saying that we had hoped that because we have here from Parliament two legal persons, one responsible for employment equity, the other one responsible for the COIDA. The problem is that the one responsible for COIDA understand that he joined, and then without notifying the chair, he disconnected if he had joined at all. So it's a matter that we'll follow up with his seniors, but also we'll follow up with the procedural officer, who's always also with us when we deal with legal issues. So outside this meeting, then I will make a follow up with the legal unit and the procedural unit of Parliament, and therefore after that, then we will conduct you and tell you what is the way forward with regard to this issue.
In regard to our questions, we haven't heard from the minister, we haven't heard from the compensation fund, and we haven't heard from the portfolio committee in all the three letters that we wrote.
Yes, those are the issues that will form part of our discussion with the legal unit and the procedural unit of Parliament. And then we take it from there, and then we conduct you as to what will be the next step with regard to this.
Thank you very much.
Thank you so much. I think we're done now with regard to COIDA, and we have articulated what is going to be the process forward. Can we now go back to Mrs. Campbell?
Yes, Chair, they are back online, Chair.
Oh, okay. I don't know what had happened. You got disconnected, Mrs. Campbell. Are you back now?
Thank you. I am back. I really don't know at which point we got disconnected.
You were still at the start. Maybe you can start again. I'll give you another 20 minutes.
Oh, fantastic. No, you'll all be fast asleep. What we actually wanted to do was to just establish whether you had listened to the rest of the presentation from our advocate Stelzner on legal issues, before we were cut off. Did you finish that?
You mean Robert?
Yes.
No, he didn't even start.
Just 5 minutes into your thing that they stopped. So ask them to use this
Okay.
screen
All right.
presentation.
Let's do the screen sharing again.
No.
Yeah. No, start from afresh.
Okay. I think you must start. You must flash it.
Can you give Robert the sharing the rights again, Ms. Mandi?
I've already given it, Chair.
Okay. If you can fly the presentation, Robert, please.
I don't think we should. Can they screen it for us? Ask them to please present.
Sorry, Chair, if I can
think
just
if
make a sorry, Ms. Campbell, if I can just make a suggestion, Chair. I'm just looking at the screen and I see that the connection is quite poor. Can I maybe propose that they take off the video? Because maybe it will improve the connection.
Oh, okay. Can you switch off your video, Mrs. Campbell, and then you so that you yeah you deal with the challenges.
Okay. Ask them to screen it for us.
Can you screen it for us? We did send it through to you in PDF. So if you can flash it for us, then I can make the commentary as we go through.
Okay. Enrico? Is Enrico still here? Official just disappeared.
Chair, I will see. Oh, there we go.
Okay. All right, we have it on the screen.
Thank you. I won't carry. Yeah. I can talk to it very easily on the screen. Thank you so much. So I won't do the introduction and our agenda again. I will introduce myself, or SAFSEC at a glance. I think I emphasized that SAFSEC has been going since 1939 and represents over 50% of employees in the industry, and that we're the founding members of the Bargaining Council for the Civil Engineering Industry. And then, because this is the Select Committee of Trade, the biggest emphasis that I wanted to make this evening was our concerns about the state of the construction industry, which is the largest employer of youth and unskilled workers. So since 2014, there's been a severe collapse in the construction market, with listed entities shedding value and many companies going out of business, listed and non-listed alike. Can you proceed along the slides a little bit, please? I've moved ahead quite quickly. To slide number 4. No, number 4, there we are. Thank you so much. We've also had a problem with the flight of skilled employees of all demographics, often due to lawlessness in business forums, prevalent where service delivery is most needed. And as Mr. Campbell noted, we have a severe shortage of experienced management at senior and top management levels, and a lack of engineering skills and experience in the private and public sectors, which is an impediment to service delivery. Industry is complex with many subsectors and an extensive dependent supply chain, and our industry derives 64% of its revenue from state work, which could rise to 80% if the NDP targets are achieved. So therefore, the prospect of being barred from doing work with state is obviously of major concern to all players in our industry. And then the recent scarce skills list came out, showing that engineers are right near the top of the list, yet in the same breath, the Department of Labour aims to impose racial and gender quotas on our top management. Then from the State of the Industry address, State of the Nation address, I just wanted to point out some comments that are very pertinent to this committee, because it's a committee on trade and to our industry, that we need to create conditions for long-lasting stability and development. There should be a new consensus which recognizes that the state must create an environment in which private sector can invest and unleash the dynamism of the economy. And if there's one thing we all agree on, it's that the present situation of deep poverty, unemployment, and inequality is unacceptable and unsustainable. We all know that government does not create jobs, business creates jobs. About 80% of the people employed in South Africa are employed in the private sector. There are too many regulations in this country that are unduly complicated, costly, and difficult to comply with. This prevents companies from growing and creating jobs. We are therefore working to improve the business environment for companies of all sizes through a dedicated capacity in the presidency to reduce red tape. At the same time, we need to confront the criminal gangs that invade construction sites and other business places to extort money from companies. So that was really a summary from the State of the Nation address, which supports the issues that we have of concern in our industry. So our critical importance is that we have the potential to be the second or the third largest contributor to GDP after agriculture and close to mining. Construction sector, as we said above, employs the highest number of unskilled workers, youth and unemployed, and makes an immediate impact to reduce poverty in all areas, particularly in rural areas. And the domestic construction industry supports a large supply chain and returns value to the fiscus. It consists of a large number of businesses and represents opportunities for many entrants with low barriers to entry, i.e. unskilled workers. The urgency of job creation and service delivery for rapidly growing population via construction of infrastructure greatly eclipses the current challenges in combating COVID. We are simply not staying ahead of the ever-growing need for infrastructure delivery and maintenance in this country. That is our opinion. Our industry has been devastated and needs support and nurturing, not any form of regulation that hampers the urgent delivery expected from our industry. And then I did an overview because the previous presenters discussed engaging with the Department of Labour and commented on letters or that they hadn't received a response to. And we understand that for our industry to engage with the Department of Labour to reach consensus is extremely important. And because we haven't engaged with this subcommittee before, we just did a quick timeline to show you that since 2018, we have been interacting consistently with the Department of Labour. So if you can take me to the next slide, please. You'll see the first submission we made was November 2018 on the draft EA bill. And then we attended the Department of Labour meeting on the 28th of February, and it was very evident at that meeting that not all players in the construction industry were present. We then made a substantive submission to the Department of Labour, including stats, data, research, and highlighting issues of concern, and also including a request for substantive engagement. We had no response. That same submission was copied to the Commission of Employment Equity, also no response on the 18th of June 2020. We wrote to the chairperson of the Portfolio Committee on the 18th of June requesting that the draft EEA bill not be presented in Parliament and referencing all our previous submissions to Department of Labour. It seemed that this was ignored and the bill was published on the 20th of July as the draft EEAB bill of 2020, which is what we are discussing now. We made a submission to BUSA in October, referencing previous engagements at NEDLAC and BUSA. And then because it became apparent that there are different sectors in our industry and that we should be seeking common consensus, SAFSEC engaged with the Construction Alliance, who presented earlier by Mr. Chris Campbell, and we started meeting with them in December 2020 and met every week to see if we could explore common ground and the possibility of common target setting, what the legal challenges were, etc. Next slide. On the 16th of February, we made a submission to the Parliamentary Portfolio Committee, copying previous submissions of the 18th of June, noting the lack of engagement and response. On the 26th of March, SAFSEC joined COIDA in making representation to a meeting of the Department of Employment and Labour, detailing our areas of concern, our stats, etc. And then in April 2021, we resubmitted to the Portfolio Committee all our previous submissions, including our research and hard copies of the previous submissions. And we made a slide presentation to the Portfolio Committee on the 15th of April 2021. Then we got to the end of last year and we'd heard nothing back from the Portfolio Committee or from the Department of Labour after 3 years of solid engagement. So we wrote to the Parliamentary Portfolio Committee asking for a record of discussions, the engagement, transcripts of legal consideration after our engagements, because it came to our attention that the bill was proceeding and was being circulated to the provinces. We received nothing. And then during the shutdown in December 21, there was a notification in City Press calling again for commentary on the EEA bill to your committee that we are discussing today. On the 20th of January, our submission went to the Select Committee on Trade and Industry, and that was basically the submission regarding the legal issues of concern, which is what Advocate Stelzner is going to discuss.
Thank you, Honourable Chair, honourable members of the Select Committee. As Ms. Campbell has explained, we are before the committee now and appreciate that opportunity, because this is the last bastion for the consideration of the various submissions that have been made over the years. And my contribution has been then the legal submissions which were made to the Portfolio Committee last year, and which have been included in a written submission to this Select Committee. And those details are before the Select Committee, and we would request the Department of Labour and its legal advisors to please give detailed consideration to what has been set out in those written submissions, because we are of the respectful view that the amendment as it currently stands will not pass constitutional muster. If I could just ask for the next screen, which sets out the various submissions that we wish to make, and address this aspect of the constitutional aspects under point 2. And the starting point, as I think previous speakers have also mentioned, is section 217 of the Constitution, which requires procurement, firstly, to be in accordance with a free, fair, cost-effective, transparent, etc. procedure. But importantly, for purposes of the current discussion, it also recognizes that there needs to be the advancement and addressing all the inequalities of the past and opening up through procurement affirmative action opportunities for everyone. And section 217(3) of the Constitution specifically then identifies how this must be done, and it requires that to be done in terms of a statutory framework. And section 217(3) of the Constitution was then given effect to when the Preferential Procurement Policy Framework Act in 2000 was passed. That's referred to variously as here as the Framework Act, also the Procurement Act, or the Triple PFA. But that act is the act which then gives effect to section 217(3), and that is the act which then sets out the procedures which need to be followed when giving effect to affirmative action and procurement. And that act still stands. That act has not been amended. And that act, as I've said, is right up next to the Constitution and based on the doctrine of subsidiarity. If there is an act which gives effect to a constitution, well, then that act must be given not only importance, but preference to the extent that it would even be the act that one looks at instead of the Constitution when parties have to exercise their rights. And it also circumscribes the powers of the minister, etc. Now, what the Employment Equity Act Amendment Bill seeks to do by now instating section 15, which has been on the statute books since 2009, but is only now being given effect to, and in terms of this amendment, and will be promulgated should the amendment be passed, is to set a prerequisite in the form of a certificate from the Minister of Labour that companies who wish to tender for government work must first get this certificate of compliance from the Minister of Labour before they can exercise, before they can engage in the procurement and tender exercise, which the Framework Act spells out in terms of Section 2 of the Triple PFA, there is the 80-20 or the 90-10 scoring system. And for that scoring system to apply, there is no threshold, there is no prerequisite of a certificate. Now what one has is that in another act, the Employment Equity Amendment Bill, if it becomes an act, that threshold requirement is being introduced. This has been attempted before by the Minister of Finance in terms of regulations which were passed in 2017, procurement regulations, in terms of which then government entities and organs of state and those who were advertising for private companies to do business with the state were then permitted to set such a prerequisite which fell outside the provisions of the Section 2 of the Framework Act. And the Constitutional Court, in the case which we've referred to there, a week ago, on the 16th of February 2022, struck down those regulations of 2017 on the grounds that they were in conflict with the Constitution, and they were then ultra vires the act which gives effect to Section 217, the Framework Act. So the simple point we wish to make, and these arguments are all spelt out in greater detail in our written submissions, is that the Constitutional Court, as recently as last week, has now struck down a provision which is similar to the one which Section 15 of the Employment Equity Act Amendment Bill seeks to introduce, namely to set a threshold requirement.
3 minutes.
Those are our submissions. Thank you, Mr. Chairman. Thank you.
No, I was indicating that you still have 3 minutes.
Oh, 3 minutes. Sorry, I thought 20 minutes was up. Thank you, Mr. Chairman. Thank you. I appreciate the opportunity. We have done a detailed submission, and a number of other conundrums which now arise because effectively procurement is being regulated in an employment piece of legislation. So the Employment Equity Act refers to the Minister of Labour, who has powers under that act, and the Minister of Labour and members of the Department of Labour are now, in terms of the amendment, going to have powers which they exercise in a procurement context. And the problem then is if someone wishes to challenge, for example, the failure of the government department to award a tender to a bidder, and there's a Section 15 issue, do you go to the Labour Court? Because the Labour Court has got exclusive jurisdiction over Employment Equity Act matters for that issue, when it is essentially a procurement issue, and procurement issues are dealt with under the Promotion of Administrative Justice Act by the High Court on a different basis. So those complications present themselves when one has these parallel attempts to address an issue which is clearly and essentially a procurement issue and needs to be dealt with within the procurement framework in order for it to be compliant with Section 217 of the Constitution. So those are our submissions as far as that's concerned. Thank you once again for this opportunity.
Thank you so much, Robert, for the presentation, and also thank you, Mrs. Campbell. Honorable members, are there any questions of clarity? Honorable Tango, I see your hand is up. Hold hand. Okay, it looks like there are no questions for clarity. I would like to thank Mrs. Campbell and Mr. Stelzer for the presentation. As a matter of the processes, the presentation has been shared with the Department of Labor, Employment and Labor, and as I indicated earlier, that on the 8th of March, we will reconvene and hear the responses of the department to all the submissions. And then on the 15th, the committee will deliberate on your inputs as well as the inputs of the department in terms of the responses. At this stage, I just want to check if the department has got copies of all the presentations that have been presented. Mr. Mkhalip and Mr. Mataf got all the presentations. Mr. Mkhalip? Oh, Commissioner, I see you still but I don't see your mic. Mr. Wabao, can you check your team? Can you check your team?
Chair, I can check the team, but I can confirm that we have received all the.
You got all the presentations?
Yes, yes.
Oh, thank you so much. Yeah. Okay.
Yeah, we got them from Adia.
Oh, okay. So that means then you'll be ready on the 8th of March to present. Okay, thanks, Mr. Oba. At this stage, let me thank honorable members. I know we at the meeting until it's just after 10, almost 5 past 10. Let me also thank all the presenters that have come, that have responded to the advert that came to present. I know, as Mr. Campbell is indicating, that the advert was yes in December. We're still working in December as a NCOP. I think our last day was, I think, just before Christmas. Actually, it was after the 16th of December. So we're still working during that period. So for us, it was not a really shutdown. But we extended it to the middle of January to allow those who couldn't see it in December to continue sending the submissions also in January. Thank you very much to all of you for the response, honorable members, Department of Employment and Labor, Office of the Chief State Law Advisor, the legal unit. I see Mr. Jengan is back, but I will talk to him outside the meeting so that we don't delay the members. We thank the staff of the committee as well for their assistance to ensure that the meeting is a success, and also other members of Parliament, staff members of Parliament, those that are making sure that the deliberations are aired on TV and other social media platforms. Thank you very much to everyone. And the meeting is adjourned. Good night.
Thank you, and good night to you too.
Good night. Thank you.
Thank you so much.
Thank you very much, Chair.
Thank you. Thank you very much.
Recording stopped.